Shoot.
Hello and welcome to the 10th day of the Clauchrie wind farm inquiry. Today we will commence an inquiry session on the topic of radar mitigation. I first ask the parties taking part today to introduce themselves and just to check that their technology is working. First of all, who's appearing for the applicants?
Good morning, sir. Ewan McLeod from Shepherd and Wedderburn, and I hope you can both hear and see me at the moment.
Yeah, you're coming through loud and clear. And we're expecting to hear from Ms. Mackenzie and Mr. Wiley today.
We are, sir, that's correct.
Thank you. And for Glasgow Prestwick Airport, please.
Good morning, sir. It's Ewan Brown for the airport.
And we're expecting to hear from Mr. Thompson, Mr. Smith and Mr. Kirkland today, or in this week.
Yes, sir, this week.
Okay, thank you. Now, my signal has been breaking up a little bit over the last couple of days as well, but hopefully I'm coming through loud and clear now. If we have any difficulties, then I'll have to turn my video off as I did yesterday. So please let me know if you can't hear what I'm saying or if it's breaking up. As usual, can I ask people please to mute themselves when not speaking, and for those who aren't participating in the hearing to turn their videos off. I made various announcements at the start of the inquiry regarding such matters as the webcasting of proceedings, COVID restrictions, and the inquiry timetable and process, which I won't repeat now. But these can all be viewed on the webcast for the 24th of May, available on the DPEA webcasting site. Now, before we proceed with the hearing of any witnesses today, I think we've got a couple of matters, more procedural matters to discuss. First of all, I've just received a statement of agreed matters, which I haven't had a chance to, I printed it off. I haven't had a chance to look at it in any great depth, but that looks to be helpful. Mr. McLeod, do you have any background to give me on the statement or anything further to say about that?
Just very briefly, sir, it's been the product of a couple of months of work. We issued a statement to the airport back in April, and we had some comments back last week. And over the course of the weekend, we've managed to reach agreement on matters which are not in contention between the parties. So it hopefully provides a solid base for you to make some findings on some of the background information. I think I was just having a look at document numbers, and I think we're up to CD 9.27 in aviation, and I think this could become CD 9.28, but I will check that in the course of the day and just confirm that for sure later on, if that suits.
That would be fine. Yes, I'll note it down as CD 9.28 for now. Thank you. Mr. Brown, anything to add about the statement? I think you're on mute, Mr. Brown.
Sorry, sir. Yes, nothing to add other than it was unfortunate it arrived at the start of April for consideration by the airport, just at the point when we were getting into the intensive phase of preparation for the inquiry. But however, we have it now, sir.
Yes, it's useful to have it now. No blame need be apportioned for its late arrival. That's fine. So the second matter was the letter from Mr. Rees of Turner. So I've read the exchanges between Ms. Cornelius and Mr. McLeod up to Ms. Cornelius's email of 6:21 last night. And on the basis of that, it does appear that Mr. Rees's letter could contain some useful information to inform my report. So I have now read the letter. And Ms. Cornelius's email last night proposed a way forward. Mr. McLeod, have you had a chance to read that email and discuss it with your clients? And do you support?
I have, sir. Yes, I have, and I've spoken to Mr. Brown about it as well. Indeed, Mr. Brown and I had several conversations about the issue over the weekend, and I think we're broadly agreed that it would make sense for you to receive some further information from Terma, and that the radar experts would then be given an opportunity to consider that and come back and give evidence in the overspill days towards the end of the month. The one issue that Mr. Brown and I hadn't quite reached a landing on yet was the question of Miss Kilpatrick and her evidence for the airport. And my slight concern at the moment is that Mr. Brown and Miss Cornelius were proposing that Miss Kilpatrick be held over until that final week, so 24th and 25th, as I understand it. 23rd had been proposed as a possible date when we could start the radar session after the condition session. Now, unfortunately, that does not work for my radar witness as things stand at the moment. So I think we're probably limited to the 24th and the 25th for whatever remaining evidence we need to get through. I don't want to find ourselves in a situation where, despite everyone's best efforts, we get to the 24th and 25th, find that we still have quite a lot of evidence to get through, and then have to come back at some later point in the year, because it will get problematic as we move into holiday periods, other parties' commitments, and so on. And so my suggestion was that Mr. Brown takes Miss Kilpatrick's evidence at some point this week, and I've indicated to him that I would not have any difficulty if he wanted to bring her back to give further evidence, having seen what Terma ultimately produce. But I would suggest that in terms of the efficient running of the inquiry, it would probably make sense to have her evidence this week as well, and keep the 24th and the 25th in reserve simply for the two radar experts.
Mr. Brown, would that work for you and Ms. Kilpatrick?
Well, sir, the issue is obviously that Ms. Kilpatrick's evidence is posited on the radar evidence, and it's never ideal to take witnesses out of turn in the way suggested, and it leaves the residual possibility that she may have to be recalled to give further evidence, sir. I think there is advantage, sir, in hearing Ms. Kilpatrick in close proximity to the radar evidence when it's known particularly what Terma's position would be. I think that would help with her evidence. And so, sir, the airport's position remains that its preference is to take Ms. Kilpatrick's evidence at the time of the radar evidence being heard. But given that Ms. Kilpatrick leaves on the evening of the 24th for a family holiday, it's appreciated that there may have to be some adjustment to the timetable. So the proposal from the airport is that Ms. Kilpatrick should give her evidence on the 24th. At least by doing that, there is no gap between that and the radar evidence. And when we know Terma's final position, that should actually make it easier alone for Ms. Kilpatrick to give evidence on the 24th. So, sir, the airport's preference is to start with Ms. Kilpatrick on the 24th. I think it has to be borne in mind that the objective and the hope of involving Mr. Rees in this is that it should curtail the evidence which the radar experts have to provide. And I think it also has to be borne in mind that according to the current timetable, we were to have 4 days this week to hear the radar evidence and the policy evidence and the airspace evidence and Ms. Kilpatrick. So having regard to that, I think that 2 days to hear 3 witnesses should be more than sufficient, particularly when the hope is that the evidence from the radar experts will be curtailed by that point.
Would a possibility be to hear Ms. Kilpatrick on the 23rd? I mean, I appreciate that Mr. McLeod, your radar witness, won't be there on the 23rd, but does he need to be there to hear Ms. Kilpatrick's evidence? I appreciate that would be also be hearing the airport ahead of the applicants, which would be the opposite of the normal order. But would that be a possibility?
Sir, I've just checked, and Ms. Kilpatrick would be available on the 23rd to give her evidence.
I think would be or wouldn't be available.
Sorry, would be available on the 23rd.
Again, sir, I'm just slightly concerned about trying to trying to prejudge what might come out of the radar evidence. I mean, I'm just looking at Ms. Kilpatrick's recognition just now. And if we run through it, we've got a section on the airport's operational requirements, which isn't really dependent on TERMA. We've got a section on wind farm mitigation, which is no prejudice intended by this statement, but it's general in nature. It's not dependent on any specific aspect of TERMA. There's then a section on the cost and risk of providing mitigation, which again is not dependent on anything that TERMA says. And then finally a section on SPR's approach to negotiation. So I am not convinced, to be perfectly honest with you, that Ms. Kilpatrick's evidence is, as Mr. Brown put it, posited on radar evidence. It is general in nature. It sets out the airport's position, and questions can be put to her on, I suppose, the hypothetical basis that radar mitigation is required or is not required. The detail of what that means in practice, we will hopefully hear about in due course from TERMA. But I would emphasise, I'm not attempting to be difficult in this. It's simply that her evidence, to my mind, stands alone from any detailed evidence on radar matters. And as I've said, if there were specific radar issues that came out from the TERMA submission, I wouldn't have any great difficulty in having her back on the 23rd to deal with those specific issues. But there are quite a number of points in her recognition which are separate, completely separate to radar, that I will want to go through with her. And that may take some time.
Mr. Brown, what about this idea of potentially hearing Ms. Kilpatrick twice then, having the bulk of her evidence this week, and then if there's anything new comes out of the TERMA discussion, hearing her again, perhaps on the 24th?
Yes, sir. Well, the issue is that part of the radar engineering evidence will have to cover the ongoing cost of providing mitigation. And that's obviously something which Ms. Kilpatrick will have to address from a commercial perspective. And that was why, sir, my position was that the radar evidence should come first, and that should be followed by Ms. Kilpatrick. The airport's position remains that it would be much better to just deal with Ms. Kilpatrick on the 23rd. That should hopefully avoid the possibility of her having to give further evidence after that, because by then the position will be clearer and there might be the odd hypothetical question to be left over for her. So given that the 23rd has been mooted as a possibility for any residual questions for Ms. Kilpatrick, sir, I would submit that we're better just organising Ms. Kilpatrick for the 23rd, and that should be adequate time for concluding the inquiry, sir.
Thank you. I mean, I think if the 23rd is available, then we would seem to have enough time that week to hear those three witnesses. I mean, going back to Mr. McLeod, I think you said your radar witness wasn't available on the 23rd, but perhaps he doesn't need to hear Ms. Kilpatrick if she's talking about commercial elements. Would you have any great objection to hearing Ms. Kilpatrick on the 23rd on that basis? We could perhaps only hear her. That would be the only witness we'd hear on the 23rd.
Can I just have a moment just to check availability of others in the team, because I have not checked that as yet. Having established that Mr. Ingalls wasn't available on the 23rd, I didn't go any further than that. So can you just give me a moment, sir, and I'll just check whether others are available on the 23rd.
Fine.
I'm back again, sir. Can you hear me okay?
Yes, yes.
So the key person that I would need to be available for Miss Kilpatrick's evidence is Miss Mackenzie. She's currently got some difficulties on the 23rd, although could look at rearranging something. The other point that's been made to me, though, by my clients is that the 23rd is currently set aside for conditions. And there is some concern that the conditions session might take some time to get through. And I don't know, I mean, to some extent I'm in your hands, sir, on how long you think the conditions session might take. Because again, the last thing that we want is to be starting evidence quite late in the day on the 23rd for Miss Kilpatrick and then having to have her held over until the 24th, and then getting into potential difficulties of witness availability 24th, 25th.
Well, the other factor on the 23rd is that I was looking to have the concluding discussion of the inquiry on the 23rd as well, because other parties will be here on the 23rd to discuss conditions, and I'd envisaged that we discuss accompanied site inspections and closing submissions on that day as well. So hopefully that would only take half an hour or so. But yes, certainly there's a possibility that we might not get round to hearing Ms. Kilpatrick until into the afternoon. So I suppose I wasn't necessarily thinking that we necessarily complete Ms. Kilpatrick's evidence on the 23rd, but if we could make a good start, then that would limit the possibility of us not being able to complete all this evidence that week. But if you need to think, or if Miss Mackenzie needs to have some more time to think about her arrangements, perhaps we could come back to this tomorrow morning, or at the end of the day today.
We could do that, sir. I mean, I come back to what I've said before, which is we're in this position not through any fault of the applicant. There is a need for further evidence as a result of what happened last week. We are keen to make good progress this week and certainly don't want to have any risk that the inquiry cannot complete by the 25th of June. Now, as I say, there are large elements, probably all in my opinion, but there are certainly large elements of Miss Kilpatrick's evidence that have got no relation to radar at all. And if we're already envisaging the possibility of her being questioned over a couple of days, my question for the airport is, what is the harm in having the bulk of her evidence heard this week with a recognition that she may need to give some further evidence on the 23rd or 24th to deal specifically with radar? And I still don't understand that point.
Mr. Brown?
Yes, sir. It's perhaps unfortunate that the question of how the terma letter came to be obtained has been raised again. The airport's position was to park that for later consideration. That's not helpful when we're trying to find a constructive way forward to assist you, sir. But my position remains, sir, that there will be merit in Miss Kilpatrick's evidence being heard proximate to the evidence from the radar engineers, and given that she is available on the 23rd, and we could make a good start with potentially later finishes and earlier starts, I don't see how it's going to take 2.5 days to get through Miss Kilpatrick's evidence and the evidence from the engineers, the radar engineers, given of course that the strategy and the intention of involving Mr. Rees is that it should truncate the evidence which has to be led from the engineers. So, sir, the airport's preference is still to deal with Miss Kilpatrick on the 23rd.
I think I'll hold over a final decision on this until we've got more information on Ms. Mackenzie's availability on the 23rd. I mean, I think I'm slightly in your hands as to how long it'll take to hear these witnesses and how long the cross-examination will take. I would certainly hope that we could get through those 3 witnesses in 2.5 days. So that sounds fine to me. But if you're going to tell me that you're expecting your cross-examination to take longer than that, then we will need to think about a different arrangement. But I think we'll perhaps leave it there for now at this point, and we'll come back to it at the end of the day, or even tomorrow morning, and make a final decision then. The other point was about possible questions for Mr. Rees and further evidence from him. Mr. McLeod, is the suggestion that a joint set of questions is prepared from your side and from the airport side, and then that is put to me for my agreement, and then it is issued by the DPEA as a formal procedure notice to Mr. Rees to provide evidence by a certain date?
I think so, sir. I mean, we're in your hands to some extent. What I discussed with Mr. Brown over the weekend was the applicant coming up with an initial list of questions, and that is being worked on today. That then going to the airport and us hopefully reaching agreement on what would be useful for you to hear, sir. Now, obviously, you may have some questions of your own, and I'm inviting you to chip into that process as well. So if there are particular things that, having read the Terma letter, you want to raise, then obviously you're perfectly entitled to raise them. As to procedure, as I say, I'm in your hands. We can either do it informally, or if you would prefer to issue a procedure notice, I'm very happy for that to happen as well.
I think the procedure notice is a little bit more clunky. I mean, it requires more process and then some turning around administratively at our end. So it would probably be quicker if possibly the airport could use its contacts to get the message to Mr. Rees quickly and get his answers quickly. So I'm happy for it to work that way. That seems fine by me. So if both parties are happy to go down that route, then that would be, I think, the best way. But I think it might be useful for me to see the questions first before they go out, just for the reasons that Mr. McLeod has said. So does that sound acceptable to both of you, Mr. Brown?
Yes, so that's acceptable from the airport's perspective, and of course the airport will facilitate the questions going to Mr. Rees. He has indicated that if he has those questions by the 14th, he will respond by Friday the 18th, which allows time for consideration of the answers before the next session the following week. Although Mr. Rees did say that, subject to other commitments he has, that he may be able to provide his answers sooner. He would use all reasonable endeavours to get them back, his answers back as soon as possible.
And we may be able to get the questions to him before the 14th. If the suggestion is that the questions are being drafted today, then if I could see them tomorrow, yeah. Okay,
yes, of course.
Yeah, is that acceptable to you, Mr. McLeod?
Yes, sir, it is. Thank you.
Okay, well, we'll proceed on that basis then. Any other procedural points we need to address now?
For me, sir, no.
Not from me either, sir. Thank you.
Good. Then if I could turn to you then, Mr. McLeod, to lead your first witness, please.
Thank you, sir. So the first witness for the applicant in this session of the inquiry is going to be Miss Anne Mackenzie. And Miss Mackenzie has a precognition and an inquiry report which is available. Miss Mackenzie, if I could ask you to read your precognition, there will be a couple of points where I'll stop you and ask you to comment further. And I'll maybe just do that from at the very outset. In paragraph 1 of your precognition, you mentioned that details of your experience are set out in paragraph 6 of the inquiry report. I think it's actually paragraph 5. But I just wondered, could you just explain to the reporter your role when working at Glasgow Prestwick Airport, because it will be obvious from the inquiry report that you have worked for the airport in the past?
Yep. Yes, thanks, Mr. McLeod. I worked at Prestwick from 2005 to 2011. I oversaw effectively the whole wind farm issue, the strategic safeguarding of both Prestwick Airport and Manston Airport, which was the other airport in the UK owned by Infratil Airports Europe Limited. I was also involved in, my title was Group Manager Corporate Strategy, and was involved in basically a lot of regulatory issues, such as regulatory sponsors on things such as administered incentive pricing for radio spectrum, engaging with the National Planning Framework and those types of kind of consultations, aviation duty and what became air passenger duty, and that whole regulatory side. But I was also involved in kind of working through for the airport company, our relationship with the airports, our relationship with Ryanair, our fixed-based operators, our fuel farm, and generally quite a broad-ranging portfolio. We were only a small team, and I was involved in a lot of that and had visibility of a lot of that, and also the business case that Infratil endeavoured to follow to enable Prestwick to be profitable, which did include fixed-based operations, military traffic, and freight and all those things, as well as the Ryanair and passenger traffic. So just to give a background, it was quite a broad-ranging portfolio I was involved with, as well as the wind farms work and the regulatory work. And since 2011, I've been with Scottish Power Renewables. So do I just...
Thank you very much. And then if I could just ask you to read on from paragraph 2 onwards, please.
Glasgow Prestwick Airport, GPA, objected to the proposed development, and I referenced the objection letter, CD 2.1.9, on the basis that GPA's radars will detect 11 of the proposed development's 18 turbines, and the GPA requires a commercial wind farm mitigation services agreement, or WMSA, to be signed before it will remove its objection. My precognition principally sets out the applicant's response to GPA's case on wind farm mitigation. It should be read in conjunction with my inquiry report, which is AP 3.3, and the evidence of James Wiley and Richard Inglis. The requirement for radar mitigation. Paragraphs 1.2 and 2.6 of CAP 764, which is CD 9.4, make it clear that mitigation is only required where wind turbines have an impact on an air navigation service provider, or ANSPs, communications, navigation and surveillance, or CNS, infrastructure, and that the CNS impact attributable to the wind turbines has a detrimental impact on the air traffic service, or ATS, provided by the ANSP. The applicant considers that the impact on GPA's radars attributable to the proposed development's turbines, if any, does not have an detrimental impact on GPA's ATS. Mr. Wiley and Mr. Inglis provide further details on these points. The applicant flowchart at GPA 22 sets out GPA's wind farm primary radar safeguarding assessment process. According to GPA 22, the only assessment undertaken by GPA in determining whether to object to a wind development is to ascertain whether any of the wind turbines are in radar line of sight, or RLOS, of its radars. At no point in considering whether to object or maintain objection does GPA undertake any assessment whether the effect of the wind turbines on its radars has a negative impact on its ATS. The assessment process is in direct contradiction to CAP 764. GPA appears to assume that radar clutter has an automatic adverse impact on its ATS without ever undertaking an operational analysis, considering the topics enumerated in paragraph 2.38 of CAP 764 and addressed by Mr. Wiley in AP 3.1 paragraph 2.1.6. However, If the presence of clutter alone, of whatever cause, has such an automatic adverse impact on GPA's ability to provide a safe surveillance-based ATS, then query how GPA's controllers managed to provide such a service using its currently operational S511, given the extensive non-turbine clutter exhibited in videos GPA 41, GPA 42, GPA 44, GPA 46, GPA 47, and GPA 48. It should be noted that the extent of non-turbine clutter appearing on GPA's S511 has increased significantly since 2007. And I referred to app 3.44, which includes some footage from 2007. We asked for radar recordings evidencing GPA's airspace usage in the vicinity of the proposed developments in our July 2020 letter to GP, or to the ECU and GPA, which is CD 9.21. Paragraph 2.37 of CAP 764 recommends the use of radar recordings as a means of identifying prevalent traffic patterns. Radar recording and the retention of those radar recordings for 30 days is required under CAP 670 to CD 9.3 in Part C, Section 1, COM 01. It does not entail a video camera being set up in the radar control room. No radar recordings under the CAP 670 provisions were forthcoming. And then until we then got this GPA submitted the videos in GPA 40 to 48 of this inquiry. GPA 40 to 48 demonstrate that no traffic receiving a service from GPA operates in the vicinity of the proposed development. Flight Radar 24 recorded GPA as having 13 movements in the 24 hours of the 8th of April 2021. GPA provided videos of 6 of those 13 movements. Therefore, the inquiry is seeing half the day's air traffic. As noted in app 3.8, GPA is a relatively quiet airport.
And I think at that stage, you perhaps, as I understand it, wanted to take the reporter to app 3.8 and just give him some further comments on that document.
Right, but that was, app 3.8 is the analysis we undertook of CAA stats. These are available, statistics available from a CAA website, dealing with all manner of airport issues.
And we'll just check, have you got a copy of that available to you, sir?
I'm just looking it up now. Just give me a moment. At 3.8, yes.
Thank you. Effectively, I mean, in the document you'll see I provide the link to where the source data can be found, and I aggregated 2 data sets, one on aircraft movements and one on passenger numbers, because they tend to be your key measures of airport activity. In part 2 of the document, on page 4 of the document, I've set out a table and the data beneath it of the aircraft movements in the essentially the major Scottish airports in the period 1990 to 2020. I think we all recognise that 2020 was a very bad year for aviation. No one's been flying anywhere. But the key point, I think, is, I mean, 2 key points here is that while Prestwick was a very busy airport in 1990 due to a large number of training flights by the then operational Jetstream operations at BA Systems operations at Prestwick, it has been dropping, and since 2015 has had the lowest number of movements for any of the big 5 Scottish airports, having been passed by Inverness in 2015. I think the key thing, and I think the next part is the really interesting part about actually the nature of the traffic that Prestwick has. Prestwick makes much about it having a very diverse and different business model. But if we look at 2.2, I have both the graph and then the numbers represented in the graph beneath it. But if we look at the graph, the blue line at the front is commercial air transport. So that's basically your commercial passenger and freight transport. So your Ryanairs, your Cargo Luxes, and other such aircraft. The purple line, which is about 4 lines in, represents Aero Club flights. These are the small aircraft that are based at Prestwick and usually have preferential rates for staying at the airport. And Prestwick has, as I recall, at least 2 resident Aero Clubs. The other kind of key areas where Prestwick does have quite a lot of work business is in training, which is a test and training flights, which is a lime green, and in military flights, which if we move across is a, where are we? Yeah, orange, that's correct, thank you. I mean, the picture I think just shows that basically for most of its operations, Prestwick has more, well, Prestwick has variously almost as many commercial air transport as Aero Club flights, and that does oscillate, and then followed beneath by training and military. I'd note in the year of 2005, which was the year when Prestwick had the most commercial air transport flights, I think the most flights, it had 20,554 commercial air transport flights and 20,739 Aero Club flights, 4,000 odd training flights and 4,000 odd military flights. We kind of come down to 2019, then we've got 4,600 commercial air transport, 4,900 air test and training, 8,000 odd Aero Club flights, and 4,300 military flights. It does oscillate, so I do recognise in other years, such as 2017, you have more test and training flights than anything else. Sorry, so 2016, you have more test and training flights than anything else. But basically, since 2013, when the Scottish Government purchased Prestwick from Infratel, it's basically on the whole had more Aero Club flights than commercial air transport flights each year. We turn over to page 2.3, and I just picked, this is a comparison between the 3 big central belt airports, Edinburgh, Glasgow and Prestwick. And I just picked 4 years out of that 20-year period, 2003, 2008, 2013, 2018. Nothing particularly magical about those years. But as you can see, commercial air transport predominates at both Edinburgh and Glasgow. And there is a much more diverse mix of traffic at Prestwick, also a smaller, much lower mix of traffic, but that kind of issue about Aero Club and training and military, they're not actually at Edinburgh and Glasgow, although Glasgow's got a little bit of Aero Club. Edinburgh, basically, once it became busy, particularly busy in this decade, last decade, Aero Club has ceased to exist at Glasgow. It's at Edinburgh. So that's, it just is pointing out that it is quite a different airport. It is a much quieter airport than its comparators in Scotland, and it has quite a diverse mix, which is not necessarily the revenue generation type of, which drives airports, revenues, really. Finally, just so for completeness, I also included a table on passenger numbers. Again, unfortunately, since Prestwick had its high in the kind of 2005 to 2008 period, it's sadly declined since then and has been overtaken by Inverness in terms of passenger numbers. And I note that Inverness, it obtained its controlled airspace in 2003 when it had 1.8 million passengers. It's now got 640,000 passengers. Inverness is still waiting to get its controlled airspace, and it's got over in 2020 or 2019 it had just under 1 million passengers. So it was just to give a bit of a sense of how Prestwick operates and why I kind of make the observation that what we're seeing in paragraph 8, well, what I observed in paragraph 8, and this videos provided by GPA are only, in basic, that's showing you half their traffic. And so just so we're cognizant of that.
Okay, thank you. So next section is GPA's wind farm radar mitigation scheme, please.
GPA informed the applicant in 2016 in respect of its Dessalak wind farm. The GPA's radar wind farm mitigation scheme, towards which the applicant's Dessalak wind farm contributed funds, would comprise the Termascanter 4002, TS 4002, and the Avibit radar processing and display system. The applicant further informed GPA that the applicant was further informed that GPA did not intend to use its legacy S511 in the long term and had no plan to replace it. GPA expressed its intention that the TS 4002 would be its airfield primary surveillance radar, PSR, once commissioned, with the Lowther Hill secondary surveillance radar, SSR, feed being fused with the TS 4002 primary data by the Avibit. As recently as January 2020, GPA confirmed that this was its intention. Mr. Kirkland and GPA 02, paragraph 69, confirms this, and he says, the normal method of operation at the airport will be for the Terma PSR primary returns to be displayed along with the Lowther SSR returns after they are fused in the MRT, multi-radar tracking, which is the Avibit technology. Mr. Fido and GPA 01, paragraph 5.3.1, bracket 1, and in figure 12, sets out GPA's WFRMS as comprising the TS 4002, the Lowther Hill SSR, the Avibit, and the S511 feed. However, he goes on then to state in paragraph 5.5.3, bracket 1, that the Termascanter 4002 system is provided as mitigation for the 511 radar out to 45 nautical miles from the airport. The S511 will continue to be available for limited use in the event of a failure of the Terma radar or if required for tactical vectoring beyond 45 nautical miles. In other words, both Mr. Fido and Mr. Kirkland agree that, when commissioned, the TS 4002 will be GPA's airfield PSR out to circa 42 nautical miles. Mr. Fido seems to be suggesting that as a selectable feed, the 511, as a selectable feed, would be used as a fallback in the case of a TS 4002 outage. This is not correct. The TS 4002 and the S511, as set out by Mr. Fido, are two elements of GPA's PSR system. Where any component of a PSR system fails, the ANSP is authorised to use SSR-only data to provide its ATS while it repairs its PSR system as quickly as possible. GPA currently has this SSR-only authorisation for when its PSR system fails. Once the TS 4002 is commissioned, this does not change. The CAA has confirmed to me on a number of occasions that the failure of any component of the PSR system enables SSR-only services. In 2015, another Scottish airport, ANSP, suggested to the applicant that if its infill PSR failed, it would be necessary to shut down the turbines, as the ANSP asserted that it could only provide an SSR-only ATS if its airfield radar failed. This contradicted what I had been told by the CAA as long ago as when I was at GPA, and what I knew to be the practice at other airports, so I raised it with the CAA. The CAA confirmed my understanding was and is correct and informed the ANSP that it was mistaken. Any failure of either component of the airport's PSR system, the airport PSR and or the infill PSR, i.e. the main radar and or the supplementary radar, would enable the provision of an SSR-only ATS while the relevant repairs are undertaken. The fact that the TS 4002 will become GPA's airfield PSR makes this proposition even stronger. As the videos of the Avibit display with only the TS4002 SSR combined track selected, which is GPA 40, GPA 43 and GPA 45, all clutter generated from existing wind farms in GPA's proximity is removed. The controllers are presented with a clutter-free picture. Further, as Mr. Evidence has explained, or will explain in his evidence, once the TS4002 has been commissioned, Terma envisages that it will be able to automatically process and remove turbines from the controller's displays where turbines are in excess of 500 metres apart, as the proposed developments ARLOS turbines are.
Turning to the extent of mitigation section, I'm going to have a couple of supplementary questions arising from Mr. Thompson's recognition, and it's probably as well if people just have a copy of that available before we get into section 4.
Mitigation, if required, should only command a contribution to cover the remedial works. For example, if it were necessary for a Terma engineer to attend GPA, the reasonable incurred cost of that visit could be recovered. If, as both Mr. Fido and Mr. Kirkland envisage, the TS4002, the Lowther Hill SSR and the Avibit are the three key components of GPA's surveillance suite, then the ongoing cost of maintaining this infrastructure falls to GPA. As was made clear in the House of Lords and the House of Commons debate, I cited the House of Lords debate in paragraph 24 of my inquiry report, aviation consumers, i.e. passengers, carry the cost of infrastructure and services, not taxpayers, not energy consumers.
At that point, I just wanted to ask you to comment on paragraph 33 of Mr. Thompson's recognition. For those who don't have it available, Mr. Thompson says the airport is aware of Scottish Government's onshore wind farm policy statement and the update to the climate change plan dated 16 December 2020. However, it's clear from those publications that the transition to wind farm tolerant radars, and in particular, who is to meet the cost of installing and maintaining them through the life of the wind farm, i.e. the developers or the radar operators, remains a work in progress. So I'd just like you to comment on that paragraph for the reporter, please.
I have some difficulties with this paragraph because both Steve, Mr. Thompson and I sit on the same committee. The bottom line is that Prestwick has bought a wind farm tolerant radar. It is up and it has no plans to replace its S511. The issue here is that it's about an upgrade, I guess, a step change in here. And what we've been working through is that wind farms are now part of the built environment now, and so should be part of the baseline against which surveillance infrastructure is procured. I think the issue about work remains a work in progress. It is hard to see how the basic surveillance infrastructure, without which an aerodrome could not provide a surveillance air traffic service, and which the aerodrome has formed the view is necessary for it to support its business case. So if its business case requires it to be able to provide a surveillance-based air traffic service, then the cost of providing that falls to aviation consumers, i.e. passengers or kilos of freight in effect, through the standard charging mechanisms. And I have issues about the ongoing life. If your only radar, and I perhaps touch on this later on, is your wind farm tolerant radar, then that is your surveillance suite. The upgrade to get it, the CapEx to install it may have been something that, because it may have been expedited, which could be paid for by the or contributed to by the developers, given it is also essential for the airport's own business case. So query whether it should make a contribution to its own basic infrastructure. But I think that's where my concern is here, is that the GPA's surveillance infrastructure, once the Terma is commissioned out to 42 nautical miles, which is basically where the only area where it has any interest in providing an air traffic service, and my colleague Mr. Wiley will discuss that further in more detail, but that will be provided by the Terma, the SSR feed from Lowther, which the current airport is currently procuring from NATS and paying for, and has upgraded radar display processing and multi-radar tracking system. So effectively, Prestwick has upgraded its radar and its RDP, its interface for its controllers and tracking system by the benefit of wind farmers. The actual ongoing maintenance cost, I find difficult to see why it's still a work in progress. That's why I do find this a bit kind of amorphous, what Mr. Thompson has said in this clause, and it's been made quite clear that we are trying to move to a place where we are recognising that wind turbines are part of the baseline environment against which modern surveillance systems should be procured. It may not be a single radar, it may be the way a system is configured, or it may be a way how we do things. I think that's kind of my concern with that.
Thank you. Now, Mr. Thompson, in paragraph 16 of his precognition, says that until now, when an adverse effect has been identified, developers have engaged actively with the airport in addressing the aviation objections to development via the airport's pre-construction technical safeguarding processes. They have been prepared to enter into a mitigation services agreement to compensate the airport for the mitigation which is required for the full life of the wind farm. So your comments on that in the context of what you then go on to say in paragraph 17, please.
Will I read paragraph 17 first?
Very much up to you.
Well, I think it should be put in, flowing off what I just said. I'll read paragraph 17 first and then return. GPA has to date recovered over £8 million from wind farm mitigation. See paragraph 103 of my inquiry report in the table thereunder. A TS 4002 costs in the vicinity of £3,500.
A bit more than that, I think. A bit more than that.
Oh, it is difficult to see. Yeah, it is difficult to see whether what further recovery GPA requires. The TPS 4002 can maintain at least 1,000 internal tracks, wind farm tracks, while running on a modest hardware platform, and that's from a quote from the Terma White Paper CD 9.10, page 2. There are now nowhere near that as many as 1,000 operational or planned turbines in RLOS at Prestwick. The applicant estimates that there are only circa 500 operational and proposed turbines in RLOS of GPA's radars. Turning to Mr. Thompson's statement here about paragraph 16. Well, let's be honest. The applicant did engage with the airport for DESALIC, and we did provide a contribution. And in fact, we know, in light of our contract with the airport, basically how much the airport paid for the Avibit and the Terma. So, and we know how much the airport recovered, and as well as the numbers we've found from the accounts. The airport procured that system. Well, the contract was placed in 2015 and refreshed in early 2016. The DESALIC turbines have been operational since 2016. The mitigation has still not been implemented. So there is an element of like, well, we have been played by the ball. This does suggest that 5 years of operations suggests that perhaps Prestwick didn't need to object to DESALIC after all, since it's not had an impact on its air traffic service. But I'll leave that to the air traffic controllers to have a debate about. But my concern here is that and if we go to GPA 22, it's just, oh, you own radar line of sight, therefore you must pay. And as I said, from here, we have actually ascertained how much the airport, it appears to have recovered double what it expended. And as I've pointed out, what it expended, it gives it a step change in its surveillance infrastructure and enables it to, effectively the ongoing mitigation, the ongoing operational costs of that surveillance infrastructure are against GPA's underlying business case. I have looked at, I've run some numbers because we are not privy to Prestwick's exact per megawatt approach to charging, which is a per megawatt, per developer, banded per megawatt per annum fee for the lifetime of the wind farm. But taking the SPR portfolio currently in planning scoping around Prestwick and excluding Dessalines, and counting the number of megawatts that I believe are probably detectable by Prestwick's radars, that would amount to 302 megawatts of radar turbines. Let's say if we band the costs of, we'll say, 0 to 50 megawatts at £3,000 per megawatt per annum, 50 to 200 megawatts at £2,000 per megawatt per annum, and over 200 megawatts at 1,000 megawatts per annum, that comes to an annual contribution by SPR for our portfolio of over £500,000, £552,000 per annum. I may have my numbers wrong. It might be half that. That still makes it £260,000 a year to Prestwick. And it is not...
Just to clarify there, just for the reporter's notes, in essence, you're saying that if one looks only at Scottish Power's portfolio and the amount of megawatts generated by turbines that are in radar line of sight, applying a notional figure of a few £1,000s per megawatt, you would end up paying circa £500,000 a year.
More than £500,000 a year.
More than £500,000. Mitigation services.
And I applied, I went and looked at the other wind farms in the vicinity of Prestwick, which are either in construction, consented, or in planning, and applying the same figures. In addition to the £550,000 from SPR, you would be getting, Prestwick would be recovering over £2 million from those other developers. So every year, Prestwick would be earning in the vicinity of £2.6 million from wind farm developers for a radar that costs £3.5 million only. And even if you add in an extra £1 million for the Avi bit, that is still buying a new Terma and Avi bit every second year. And if we then say that that is for the lifetime of the wind farm, and I know the issue is that we have sort of perpetual consent, but let's just, for playing with the numbers, think about an operational life of 30 years. In today's money, that would mean SPR for its portfolio would be paying £16.5 million in today's money to GPA for mitigation services. And if you aggregate all the other developments I just counted up, you come to a grand total of all those developments coming to over £79 million for mitigation services. Now, even if my numbers are incorrect, and instead of being £3,000 a megawatt, £2,000 a megawatt, and £1,000 a megawatt, it is half that. That still means Prestwick is recovering just under £40 million in today's money for a radar that costs £3 million, and which, when it comes to be replaced, being Prestwick's only primary surveillance radar, should fall to the aviation consumers at Prestwick, its passengers and kilos of freight that do pay effectively through aeronautical charges for that infrastructure. It is not energy consumers that should be funding either the fundamental air traffic control surveillance equipment, nor the staff costs of the air traffic services, nor the SSR feed provided by NATS. And I think this is where we have a real problem. If it is just a matter of, as I acknowledged before, if it was necessary for the Terma engineer to come out, then that is a cost. It's a one-off cost, which actually can be reasonably demonstrated and incurred and remunerated. So this is where I have a problem with paragraph 16. And just because everybody else hasn't done the numbers doesn't mean everybody else is right. So I think that's where I come to.
Thank you. So I think you then go on to paragraph 18, which I think summarises the point that you've really been making there. But if you want to read that, and then on to section 5.
As mentioned in paragraph 47 of our inquiry statement, GPA's approach to wind farm mitigation appears to requires payment to them of a per developer, per megawatt, per annum fee. The problem with this approach is that there is no correlation between the work required to effect mitigation and the recovery made by GPA. Continuing requirement for PSR. Mr. Fido, GPA 01, paragraph 3.2.5, bracket 3, bracket A, suggests that the provision of a PSR feed from GPA to the MOD is essential for national defence. The TS 4002 can provide this feed to the MOD when it replaces the S511 as GPA's principal airfield radar. Indeed, the MOD takes these airfield radar feeds under the Airfield Radar Integration Project, known as ARIP, on an as-is basis. This was explained to GPA in 2007 in the context of the Kyle inquiry, and following receipt of Mr. Fido's inquiry report, I reconfirmed this with Wing Commander Stephen Borthwick of the MOD's Air Defence and Electronic Warfare Systems team, who procure the ARIP feeds, on the 26th of April 2021. If it had been a concern, so if this clutter, any clutter had been a concern to the MOD, it would have proposed to it would have objected to the proposed development. It did not. In terms of the continuing requirement for airports to have PSR data, in the future, pursuant to the Airspace Modernisation Strategy, CD 9.15, ANSPs are permitted to provide their ATS using electronic conspicuity or cooperative surveillance, and ANSPs continue to be required to fund their PSR infrastructure, then airports are likely to want to remove their requirement for PSR as much as possible. This is particularly the case of relatively quiet airports such as GPA.
Just two questions on that section of evidence, Ms. Mackenzie. The first one relating to the end of paragraph 19. You say that if the issue of clutter had been a concern to the MOD, it would have objected to the proposed development, but it did not. It might be suggested to you that the MOD would feel it didn't need to object because it knew that GPA was objecting on the basis of clutter. And just your comments on that.
It has been confirmed repeatedly to me, as if back in 2007 and then more recently, that it is on an as-is feed basis. In 2007, Prestwick hoped that the MOD would bolster its objection to the Kyle inquiry, Kyle wind farm, and sought to rely on the ARIP feed as being another grounds for objection that it was integral to national defence. The MOD made it very clear to Prestwick that it was not part of that story. It took as an as-is feed, and it is basically to provide situational awareness to controllers, to augment in areas where the MOD's own infrastructure doesn't have a lot of low-level cover. So the ARIP feeds are procured. I mean, there's one from Prestwick, there's one from Bristol, I think there's one from London South End, you can find the actual contract documents in the OJU. Well, they used to be published in the OJU. Prestwick earns about, I think, was it about £70,000 a year, 60 to 70,000 pounds a year. I have got the figures somewhere. For the feed, so it was a £370,000 contract for 5 years. So it gets it, but it's just basically the MOD takes a feed and does with it what it will. It is not, none of us in this room are privy to the inner workings of the MOD's command and control systems, C2 systems. It informs this, but it is not on the same level of importance as the key air defence radars that the MOD deals with, which are dotted down, predominantly down the east coast of the UK. And I am very closely involved with this in my work as part of the offshore wind, joint offshore wind, MOD air defence mitigation task force, where we are working very collaboratively. The wind industry is working collaboratively with the MOD to find long-term mitigations whereby there won't be need for mitigation. In fact, there will be coexistence. The MOD's objective is to coexistence between air defence radar and wind turbines. So that's why the MOD just buy it on an as-is basis. And if Prestwick had wanted to find out more about this, then they should have approached the MOD and asked them whether they wanted to object. But as I said, the MOD did not want to object in 2007, and as Wing Commander Borthwick confirmed to me, it is on an as-is basis. It's just an extra layer of data. They recognise it will have glitches. And let's face it, if you look at the current 511 radar feed, which we've seen videos of, and I mentioned earlier, the amount of non-turbine clutter that is already kind of despoiling that feed, it is not a clear picture. The MOD will probably be thrilled to get the Terma picture because it will be a much clearer picture. So, and relevantly, we'll give it low-level cover over the Firth of Clyde, which is probably where the MOD is interested from an air defence perspective or a homeland security perspective, given it's on the approaches to Faslane.
Okay, thank you. Just wait for the reporter to complete his notes on that. And then finally, I think in terms of Mr. Thompson's precognition, paragraph 39 of his precognition on page 5 deals with the ongoing need for primary surveillance radar. And he says, the airport vigorously rebuts any contention it does not require a PSR. In view of the diversity of our traffic and our strategic support role in respect to the security of UK airspace, the continued availability of PSR is a crucial component to enable the airport to continue to provide a safe and efficient airspace. And again, just your comments on that for the reporter, please.
Yeah. Well, I think I have answered the security point. The security point is it's an as-is feed and it will be replaced by the Terma, I would expect, because it will be outputting in the relevant code, asterisk feed. In terms of the continuing requirement to have it for its Prestwick services, as I mentioned, if the airport, with the coming of the airspace modernisation and mandating in the fullness of time of electronic conspicuity, if the airport can provide a service without having to incur the cost of maintaining a primary surveillance radar, then I would expect the airport to seek to do that, because it will remove a not insignificant cost from its annual operating expenses. It will only do that once it's safe and it's permitted, but this is the general direction of travel. And in this regard, I would actually take if I could take the reporter to app, which is the Airspace Modernisation 2020 Progress Report, app 3.9 or GPA 08. There is some interesting information about what can happen in this environment.
That was APP 3.9.
Okay, I've got that. Okay, I've got that.
And I take you to page 74, paragraph 3. And I don't have the electronic version, but I assume it's the same. Paragraph 3.43. And this is about what's actually happening in the context of north of Scotland, where the CAA is working. This is in the kind of stakeholder and engagement section of the report. And it talks about the activities being undertaken by the CAA to further various the objectives of the airspace modernisation strategy. But in paragraph 3.43, this talks about how the CAA has carried out engagement with the Ministry of Defence, NATS en Route Limited, or PLC, and Highlands and Islands Airport to seek to develop a state safety assessment of cooperative surveillance to support air traffic services by Q3 2021. And this is about basically looking to whether you can, in quieter airspace, such as in the north of Scotland, a surveillance service can be provided using cooperative surveillance only. And this is not, okay, the north of Scotland is quiet airspace, and that's why it's an innovative step, and it's not written in stone yet. But the fact that this is being explored, this would mean that the Highlands and Islands airports do not have to buy primary surveillance radars. They will be able to use ADS-B and other forms of EC. The kind of things we talked about in the lighting session, and my colleague Mr. Van Hoogstraten talked about in terms of the trials at little aerodromes of ADS-B receivers to provide a safe air traffic service in reasonably quiet airspace. And I guess the question is, which brings me back to my original point about Act 3.8, the quietness of the airspace around Prestwick, given that Inverness is a high airport, may suggest in the fullness of time, Prestwick may be able to take advantage of some of these developments as well. And if Prestwick was not seeking to make wind farmers and energy consumers pay for the maintenance of its basic surveillance infrastructure rather than its aviation customers, then Prestwick, if it had to pay for its own PSR and SSR feed and maintaining its RDP and MRT functionality, which is what it would be doing in any other circumstances, but for the fact they hide behind wind farm development, then it may decide, if this takes off, again, it's early days, that it may suit them too. And that's about kind of basically layering surveillance so it is appropriate to the airspace complexity, density, usage, and still to ensure that there is a safe air traffic system. So I think that's kind of a key point, just to say things are changing. And so when Mr. Thompson says never ever, effectively in paragraph 39, I do query whether that is written in stone in the way he says it is. And I think there will be other ways in the fullness of time for a safe and safe and efficient air traffic service to be forwarded using surveillance at Prestwick. But we're not there yet, I agree. But I'm just not in a place of we should not say never. And where we're being asked to fund a mitigation solution and fund a primary surveillance system in perpetuity, which is our consent, or for 50 years or 30 years, given that the airport will be replacing its radars. Well, even Prestwick, the S511 is now 31 years old. As Mr. Smith says in his recognition, it's at end of life. Even if Prestwick manages to make this term last 31 years, since it's been turning, operating, albeit not commissioned since 2017, that takes us to 2048. That'll still be in the operational life of our wind farms. Why is it then in 2048, 2 years before? Well, 3 years after Scotland has met its net zero objectives, it may not be using PSR anymore. Sorry, I get a bit passionate about this.
Thank you, Ms Mackenzie. And then if we just finally read your conclusions, please.
Conclusion. GPA's safeguarding assessment process, as set out in GPA 22, is fundamentally flawed, as at no time does GPA undertake an assessment to determine if the impact on GPA's surveillance infrastructure arising from wind turbines has a detrimental impact on the air traffic service GPA provides. As Mr Wiley and Mr Inglis will establish, there would be no detrimental impact on GPA's ATS arising from the proposed development's RLOS turbines, and therefore there is no requirement for the applicant to sign a wind farm mitigation services agreement with GPA. GPA's wind farm radar mitigation scheme is founded on the TS 4002. The fact that GPA has currently enabled its 30-year-old planning radar, the S511, to be selected as a feed in its Avibit display does not mean that the S511 forms part of the mitigation suite. This is acknowledged by Mr Kirkland and Mr Fido. More importantly, an outage of either component of GPA's PSR system, being either the TS 4002 or the S511, would enable GPA to provide an ATS using SSR only on a temporary basis as it repaired its PSR system. GPA's proposed methodology for charging wind farm developers for mitigation services is in no way cost reflective. GPA has already recovered twice the cost of its TS 4002. GPA is seeking to recover more than the costs of deploying and operating any mitigation technology. Indeed, GPA seems to be seeking perpetual support for its essential surveillance infrastructure by electricity consumers via wind farm operators, rather than from its customers, i.e. passengers. And finally, there is no impact on the UK's air defence system by virtue of the proposed development.
Thank you, Ms Mackenzie. I don't have any further questions at this stage.
Thank you, Mr Mackenzie. That's taken us up to about 11:15, so I think we'll have a wee break there and come back at 11:25, please, and we'll hear from Mr Brown for his cross-examination. So I'll see you at 11:25. Hello, that's 11:25 then, if we can make a start. Ms. Mackenzie, are you back with us?
Ms. Mackenzie.
Yeah. All right. Oh, yeah.
Sorry, it's Amy Cornelius on the entrance here. We're just having to change over Mr. Brown's setup, so we'll just be a minute. If you could just bear with us, that'd be greatly appreciated.
Okay, fine. We'll hold on.
Sir. Sorry, sir, I'm just checking that we now have a better means of relaying the inquiry.
I can certainly see you and hear you fine now.
Thanks.
Coming over loud and clear. So
Thanks.
if you'd like to commence your cross-examination now, if Ms. Mackenzie is back with us.
Yes, thank you.
Okay, thank you.
Yes, Miss Mackenzie, good morning again in the inquiry. Now, we obviously had a session before dealing with aviation lighting, and in that context we dealt with electronic conspicuity. And my intention is not to revisit all of that, but there may be some elements of that evidence which should be reconsidered in connection with the current matter. So on that basis, sir, my intention is not to take up further time in the inquiry, and I'll make submissions on electronic conspicuity relying upon what went before there. Now, Ms. Mackenzie, when you were giving your evidence in chief, you referred to the fact that you had previously been at the airport and that you were involved in the safeguarding process for the airport and for Manston. And I believe you said that you left the airport in July 2011.
Yes, I did.
And so far as the concept of mitigating wind farms is concerned, have we not moved on since 2011 in that we now have wind farm tolerant radars which are available?
Oh, that's interesting that you acknowledge that what Prestwick has purchased is a wind farm tolerant radar. I'm glad you did that. There are now, well, no, actually in 2011, there were people who were saying their radars would work. But I think the move to require radars to automatically, either systems to be configured or individual radar components to be able to differentiate and manage air traffic turbines has improved.
Yes.
And
yes.
Yeah.
Just to be clear, Ms. Mackenzie, when I a wind farm tolerant radar, of course, that's an issue in dispute between the airport and SPR, is it not, about whether further work is required on the terminal which has been purchased to accommodate new wind farm developments as they come along.
Well, there is only Terma says that wind farm, the radar has a capacity for wind farm tolerance. Terma has been very active in this market, and clearly it is quite a clever modern radar. The question as to whether modifications need to be made to the Terma does depend on whether mitigation is required. So we come back to my initial point of it's only if there's a detrimental impact in critical airspace. Prestwick currently operates with a large amount of clutter, both turbine and non-turbine generator clutter. It has done that for many years, and it provides a safe service. So there are some places where clutter is not of a major concern to impact on the provision of a safe and efficient air traffic service.
Well,
I'm glad you felt there was a wind farm tolerant radar, because I was excited that it was. And if it is a wind farm tolerant radar, then Prestwick really should just be happy that someone bought a new radar and it didn't have to buy a new radar for itself.
Ms. Mackenzie, did you not, in the answer you just gave me, say yourself that it has the capacity to provide mitigation for new development?
Only if mitigation is required.
Yes, but you accept it has capacity to provide mitigation?
No. So mitigation is, first question is mitigation required?
Well, let's proceed.
And the other next question is, which we're not addressing here because this is what the radar folk, is to what extent does actually any intervention need to be made? And that is still a matter of some conjecture, and that is not for me to comment on.
Right. Ms. McKenzie.
Our understanding of reading of the white paper with our separations distance is that it would be automatically able to deal with this. And for what it's worth, I think there has been a degree of marketing spin, perhaps, that these new radars are actually learning radars, and they actually can identify when a turbine is a turbine. And I know some of the other radar technology that is on the market can do that. It can actually differentiate, can detect and differentiate, and therefore discard without being told that something is a turbine. That's a technical issue which is probably not for today.
Indeed. But if we proceed on the hypothesis that it's concluded that mitigation is required for the SPR proposal, which is before the inquiry, you accept that the Terma has the capacity to mitigate that. I'm not asking you to accept that mitigation is required. I'm putting it to you on the hypothesis that that is the decision which is made.
Yes, my understanding was that is why GPA selected that particular radar.
Now,
That there was going to be a lot of wind farms around it. So yes, I would expect that the Terma can deal with any wind turbines up to 1,000 at least on its current processing capabilities. And as I've noted, we can only count about 500 that are in radar line of sight of Prestwick's Terma currently.
now, Ms. McKenzie, was there not a point in time when, in order to accommodate the development of wind farms within a radar line of sight, that airports had to consider workarounds to manage the problem of clutter created by wind farms within the radar line of sight?
Never has, apart from what was in the MATS Part 2 about the gap between Windy Standard 1, which is not on the GPA's maps. I find that interesting since it's the oldest wind farm that is visible to them, and Hare Hill, not Hare Hill Extension, because Hare Hill Extension is over the hill from Prestwick. Hare Hill, which is also not on GPA's map 21, about taking aircraft down there. And there was a provision in the old MATS Part 1, which was, this evidence was adduced back in 2007, which said just take particular care. But other than that, there's been no workarounds as far as I am aware. And since we do not have the MATS Part 2 in evidence, we cannot say that. But there were no workarounds. When I was at Prestwick, we were looking for a mitigation solution, a strategic regional solution. And at that time, we were looking for, our initial thinking was based on a terrain shielded wind radar in much the same way as Whiteley and Blacklaw have been mitigated for Glasgow Airport, Edinburgh Airport, and Nats en route by the terrain shielded wind radar at Kincardine. So that's what that was the thinking back in 10 odd years ago, 2005 to 2010. And then there was a lot of work going on about wind farm tolerant radars. So Prestwick moved with the times. And that would be better because you only have to have one radar at the airport, which is the wind farm tolerant radar, providing all your services rather than having to maintain 2 radars.
Yes, Ms. McKenzie, but you mentioned in your answer there that one of the solutions when clutter appeared on a radar screen was to take particular care. Did you not?
That was because the gap between the 2 wind farms was, I think, about 3 nautical miles, and it was on the extended centre line. But that was a wind farm that was not objected to by the airport or the CAA, who was then. So, but that is the only workaround I know about, but it did not preclude Prestwick providing a safe and efficient service. And it has been providing that service since way before 2007 with that provision.
Yes, but such workarounds.
There are no provisions about anywhere, again, but I have no idea if Prestwick has implemented workarounds for any of the other wind farms although I note that in its airspace change proposal, it didn't suggest that wind farm clutter was at all an issue. And then, as my colleague Mr. Wiley will note, put an instrument flight procedure right over the top of the Desalic wind farm.
Yes, well, I'll ask Mr. Wiley about that when we get to that stage in the evidence. But the fact is that with a wind farm or with a radar which has the potential to accommodate a development without having any adverse effect on the clutter on the screens, does that not mean that we no longer have to accept workarounds or temporary measures in the airspace?
That's what Prestwick says, and I'm very unclear as to why Prestwick says that, because then Prestwick also says that it doesn't know if its mitigation solution it's selected works. But given that the first point is if there is any impact on the radar, and there's not clear that there is any impact on the terma, would it have a detrimental impact on the air traffic service? Again, we disagree on that. We clearly disagree on that, the two parties. But then saying that the screen has to be then clear of all clutter from any source whatsoever, or it's just all wind farm clutter. It's very unclear to me. The airport can continue to provide a safe service. That's all that should be of concern. So having a rule saying, now that we've got a wind farm tolerant radar, which by the way, we don't know how wind farm tolerant it is because we're not prepared to warrant that to you. We don't want to have any clutter. It doesn't seem to logic. It is about the detrimental impact on the air traffic service provided. So we can dance around workarounds, but then there will always be, I mean, the SSR only provision is a temporary workaround because providing an air traffic service using SSR only is still safer than providing a non-radar based service. And given that all the radars in the surveillance suite are subject to the same safety case and subject to the same requirements to repair in times. Yeah. So you're, I think, trying to say to me, should we accept any should there be any workarounds? I think it has to only determine if there's an impact on the surveillance infrastructure and an impact on the ATS provided, and then a decision is made.
Yes, but did you
rather than a per megawatt per annum per developer fee ad infinitum, which in no way, shape, form reflects the costs of mitigation, surveillance infrastructure.
Yes, Ms. Mackenzie, but do you not accept that if mitigation is required, and again, on the hypothesis that it is required, that optimising the terma would be a reasonable, achievable and timely mitigation?
If it cannot be done, no, I think I actually haven't acknowledged as much, to be perfectly honest. If it is not done automatically. So, yeah.
So is that a yes?
I think if we look at bottom of, I think I did actually acknowledge this. If paragraph 15, mitigation if required, no. If, for example, paragraph 15 of my recognition, mitigation if required should only command a contribution to cover the remedial works. For example, if it were necessary for a thermo engineer to attend GPA, the reasonable incurred cost of that visit could be recovered. So we haven't actually ascertained that it is necessary. If it were necessary, that one-off cost for it to be recovered, then it may be necessary. Yeah, but I've acknowledged that already.
Yeah, so just give me a moment, please. Yes, Miss Mackenzie. Sorry, sir, I've now found in your inquiry report. You refer to the principle in cap 7, sorry, this is paragraph 93.
Turn over.
Yeah, and it says there that cap 764, paragraph 1.213 states that mitigation, if required, should be reasonable, achievable and timely. GP has selected its wind farm mitigation, the TS4002, and the Aviation display system, which for reasons set out by my colleague Richard Ingalls will, once commissioned, automatically remediate any wind turbine impacts of the proposed development. Now, I've acknowledged that there's an issue before the inquiry about whether mitigation is required, but just to be clear about this, are you saying that if mitigation is required, that the use of TERMA to mitigate the effect would be a reasonable, achievable and timely mitigation?
Prestwick procured the TERMA scanter on the basis it was a wind farm tolerant radar. I would be very surprised if Prestwick thought they had to then go and get another surveillance sensor to augment its currently wind farm tolerant radar. So I think it is fair to say everybody in the vicinity, every wind farm developer in the vicinity of Prestwick, and the same can be said for probably Glasgow Airport, Edinburgh Airport, Teesside Airport, and Newcastle Airport being the airports at the moment with TERMA scanners at their airports, would expect that the TERMA scanner 4002 would be used to provide the mitigation or to remediate the situation. So
No, I
if
think
mitigation is required, then yes, but are you suggesting that Prestwick needs to buy new equipment to purchase to remediate Clauchrie? And that's the first that we've heard of it.
Ms Mackenzie, I'm not putting evidence before the inquiry here. We know the issue in dispute here is that the capabilities of TERMA, and you know that the airport's position is that further optimisation of the radar is required. I know you don't accept it, but I'm just telling what the airport's position is.
I understand that, but the airport has said, I think this is the key point, we've said, I have acknowledged that if mitigation is required and mitigation entails an optimisation of the TERMA, then the reasonable costs of the TERMA engineer would be fair.
So, yes, so you would accept then.
But that is not a per megawatt, per annum, per
Ms.
developer
Mackenzie,
fee
I can assure
and
you
infinitum. So I think that is the point. So if it's let's say it's £20,000, well, it's £20,000. It's not £500,000 a year for the next 50 years.
Ms Mackenzie, I appreciate you want to say much about the megawatt charge, and I assure you that I'm going to come to that. But for the moment, Ms Mackenzie, if optimisation is required, would you accept that as being reasonable, achievable, and a timely way to mitigate the effect of the development, which is before the inquiry?
Mitigation is required, yes.
Yeah. Now, can I take you to paragraph 6 of your recognition, please? Well, actually, paragraphs 5 and 6. In paragraph 5, you talk about GPA's wind farm primary radar safeguarding assessment process. And you have said in the second half of that paragraph, on the third line, the line starting of the turbines, there's a new sentence towards the middle of that line. At no point in considering whether to object or maintain an objection does GPA undertake any assessment whether the effect of wind turbines on its radar has a negative impact on its ATS. The assessment process is in direct contradiction of cap 764.
And moving on to paragraph 6, GPA appears to assume that radar clutter has an automatic adverse impact on its ATS without ever undertaking an operational analysis considering the topics enumerated in paragraphs 2.38 of CAP 764. Now, Ms Mackenzie, is the fact not that you don't know what internal processes the airport may employ to ascertain whether there is any operational impact?
I would take you to the very words of GPA 22. Step 1, consultation. Step 2, conduct radar line of sight analysis. If visible, object. If not visible, don't object. Step 4, object. Step 5, engage with developer. Where is the objection? Where is the analysis? The only thing that this flowchart shows is that Prestwick conducts an analysis of whether the turbines will be in radar line of sight.
Yes, but my fundamental question remains, Ms Mackenzie, you don't know what steps the airport take internally to ascertain whether there's an operational impact.
I would have expected that in setting out its wind farm safeguarding process, the airport would be, and particularly for the purposes of this inquiry, would have set out accurately what its internal processes are. So you're telling me that GPA 22 is wrong?
No, I'm not telling you it's wrong. I'll hear from Mr Thompson on the processes which are taken, but if...
Just intervene at this stage, sir. I don't want to cut across Mr Brown's cross-examination, but I am slightly concerned from the line of questioning here that there may be evidence as to GPA's internal processes that have not been put in front of the inquiry so far. This picks up on the point that Ms Mackenzie just made in answer. If GPA has conducted a safety assessment, that should be before the inquiry now in written form. In fact, it should have been before the inquiry months ago in written form, in order that my clients could have assessed that and commented on it. And I'll say no more at this stage than I will be objecting if there is any suggestion that there is a further safety assessment that's been undertaken that has not been produced at this stage.
Thank you for that. Back to you, Mr Brown.
Thank you, sir. Well, we can deal with that when the further evidence comes. Now, in your precognition, Ms Mackenzie, you said at paragraph 7 that you'd asked for radar recording evidencing GPA's airspace usage in the vicinity of the proposed development in your July 2020 letter. And you say that paragraph 2.37 of CAP 764 recommends the use of radar recordings as a means of identifying prevalent traffic patterns. Now, could we go please to CAP 764, which is CD 9.4. And we see there that what it says is where possible, it can be beneficial for the ANSP, which is the Air Navigation Service Provider, to record or plot real traffic patterns over a period of time using the radar system and to use this to identify the prevalent traffic patterns. You got that?
Mr Brown, what paragraph number is that?
Paragraph 2.37, sorry, sir.
Sorry.
Do you have that, Ms Mackenzie?
I do have paragraph 2.37 of CAP 764 in front of me.
Yes. And that's the paragraph to which you refer in your precognition. Now, you have said in your precognition that paragraph 2.37 recommends the use of radar recordings as a means of identifying prevalent traffic patterns. Looking at the first sentence of paragraph 2.37, I don't see the word recommend, do you?
I do see the words "it can be beneficial." Perhaps I just read "it can be beneficial" as being "it recommends" as a way. It is in a document published by the CAA, and the CAA says, where possible, it can be beneficial for the ANSP to provide real traffic data. You take objection to my use of the word recommends. I read that as being a recommendation by the CAA. You do not. But it is noted that it can be, the CAA states it can be beneficial to the ANSP to provide recordings of traffic patterns. And as I note, this is why I suggested July last year, because it was 30 days, it was the summer, lockdown had just finished. It should have been as busy a time at Prestwick for what was admittedly a bad aviation year. And it would have given us all good insight, and it would have been the full screen picture with the audio going with it. And the reason this is important for the reporter to understand, these are the records that if there was an incident at the airport, the CAA and the Air Accidents Investigation Bureau would draw down from Prestwick. So that is, it's not just a kind of showing half the screen, it is the whole picture, the actual information that will inform an air accident investigation or any other issues. So it seemed like just using something that was already there in a time when the traffic had been, well, for 2020, a bit better. And it was at the end of a month where, then it was actually, there would be no questions like, oh, we instructed our controllers to vector in this area just to prove something. It would just be as it was. And so that's why I thought it would have been a good piece of data for us to share. And if it showed that, you know, the airspace at Clauchrie, unlike on the 8th of April this year, was chock-a-block full of aeroplanes, that would have been really interesting.
At the end of paragraph 2.37 of CAP 764, going back to that, it says, does it not, where appropriate and feasible, the recorded traffic data above a particular project may be released for further analysis. Do you know what steps the airport would have been required to take to produce the data?
No, I don't, but I know the CAA can rock in with a USB stick and take the data, at least that's my understanding.
Yes, that's your understanding.
And it would have been quite nice had Prestwick actually responded and said, this is not feasible. We cannot do this because we are prohibited by the CAA. And then I would have gone to the CAA and said, well, dear CAA, how do we do this? Because you've said it in your document, we should be doing this. And their report says it can't because you're prohibiting it from doing it. We could have had the conversation, but no conversation was had. It was a way of trying to establish the evidence to justify Prestwick's statement that this is a key piece of airspace for it, and it has lots of traffic in that airspace. Or it has at least the occasional bit of traffic in that airspace.
Thank you. Now, sir, if I may ask that my agent, Ms. Cornelius, has given access to screen share. Very helpful.
Yes, I think she's spoken to Mr. Mason, our IT guru. So hopefully they've sorted out between them how to do that. So let's see if it works.
Thank you. Now, what I would like is to bring onto the screen GPA 21F. Now, I wonder whether, just given the constraints we have here at the moment, whether we could just scroll from the top of that so that we can see what we're dealing with. So, as you will be aware, Ms Mackenzie, this is a clutter map which was prepared by the airport showing those turbines which are visible at the moment, those turbines which will become visible.
That are visible at the moment.
Sorry,
Which does basically, it doesn't show the turbines that are visible at the moment. It's missed out the bite in the SMAC, the 2000, that little kind of curvy bit at the top. That is because of a wind farm called Kelburn, to which Prestwick considered objecting back in 2009, but then decided it was actually in Glasgow's airspace. But that, which is we premeditated that smiley bit. I can't in the SMAC, and it's a bit difficult without a pointer to show you exactly where I mean. And Millen Hill has a wind farm next to it called Wardlaw Wood, which has been operational since, and these were wind farms that were there when I was at Prestwick. So I'm a bit surprised Prestwick's lost all these wind farms. One assumes, however, that Prestwick has optimised in the last 4 years, 4.5 years in optimising the Terma. It has optimised them to take away that residual legacy clutter.
Yes, well, it's actually conceded, Miss Mackenzie, that Kelburn is not shown to the north next to Miller Hill, and Mr. Thompson can speak to that. But if we scroll back,
This worries me that this particular map took a very long time for Prestwick. Prestwick needed an extra 2 weeks, was it, to draw up this map? I would have expected Prestwick to know what's in its airspace.
right,
And now we're being told by Mr. Thompson he does know it's there. Well, then why isn't it on the map?
now, Mr. Thompson will speak to that. But you mentioned there that Kelburn was, permission for Kelburn was sought about 2008, 2009. You were at the airport at that time, and you said in your early evidence that you were involved in the safeguarding process. Were you involved in Kelburn?
Also involved in Henny Hill Extension, which is why Prestwick objected.
Yes, but were you? Can you remember that you were involved in the Kelburn proposal?
Yes,
So
the conversation, because certain of the air traffic controllers were concerned that they would lose, they were happy to live with the clutter, but they would lose a level on the SMAC. And then it was agreed that the most logical thing here, given the nature of that airspace in the corridor between Glasgow and Prestwick's and Glasgow's airspace, which is that parallelogram, was that just that chop out of the SMAC took place, and that would relieve any concerns the GPA controllers had.
yes,
Also made quite, yeah, it wasn't operationally significant airspace.
so at that point, 12 years ago, 13 years ago maybe, a view was taken that the airport should tolerate that clutter.
Pity it's not drawn, but I think actually it's straddling into Glasgow's airspace. So Prestwick wouldn't be providing a service in Glasgow's airspace. But yes, and because it wasn't operationally significant, the airport could tolerate clutter because it was not an airspace the airport actually provided a service in. There was no detrimental impact on the safety of Prestwick's ATS. So having the kind of the blank screen with only the dots of the aeroplanes on it isn't the holy grail. That was recognised this is not a place that Prestwick was providing a service.
Yes, but my question to you was, did the airport decide, from your recollection, to tolerate that clutter?
What was that? Why or how?
Sorry, did the airport decide to tolerate that clutter in 2008, 2009?
Yes, it did, because it was not in operationally significant airspace. It did not impact on the air traffic service provided by Prestwick Airport.
And I think you said that you believed that the effect of Kelburn had now been removed from the screen as you understood it?
No, not removed from the stream. No, that smiley thing, which you can see, if you see the Ardrossan, the smile between Ardrossan coming around to Miller Hill from a circle, that is about this minimum safe kind of surveillance terminology. Mr. Wiley will be better at this than I am, but it's basically this surveillance minimum altitude levels. And so because it was an obstacle, it had to be reflected in that. But that did not impact on Prestwick's ATS. It just basically was warning the pilots who inform themselves when they go flying of their safe surveillance.
So sorry, Ms. Mackenzie, maybe I misunderstood you, but I thought that you had mentioned that the airport had mitigated the effect of the clutter in...
No. I said the airport had addressed any safety issues by increasing the SMAC. I may not have been clear enough on that. So that's surveillance, that's all that's now called the ATSMAC, but that little smiley bit out, that addressed any safety concerns because it basically tells the pilots what their minimum safe altitude is.
So just
the clutter is there. And if we had seen the full screen of Prestwick rather than just in the videos, the half screen that was kind of shot over the shoulder, we would have seen clutter from the Kelburn, Wardlaw Wood, Miller Hill, and then there's a bit of a gap down to Ardrossan. Kelburn's more in that area near basically in Glasgow Airport's airspace. So we must make it clear that Prestwick Airport's controllers cannot provide an air traffic service in Glasgow Airport's controlled airspace, and that's where the airspace goes all the way down to the ground, unless it's coordinated with Glasgow Airport. And given that is on the extended kind of outbound line, departure route for probably the more used radar runway from Glasgow, there would have to be coordination. Again, the air traffic controllers can speak more to this than I can, but it is not Prestwick's airspace. So it's a bit like Prestwick. If Prestwick insists on objecting to wind turbines that are visible in Glasgow Airport's airspace, which is in its control zone, I mean, it's really not an issue for Glasgow Prestwick Airport. It was an issue for Glasgow Airport. Glasgow Airport could deal with it. It was much more critical for Glasgow Airport, but they could deal with it too.
But those screens...
Mr. Kirkland actually probably could talk to that as well if you wish to ask him about it.
Those screens to which you have referred to of the videos, they're using the old S511 radar, are they not? Or some of them at least?
Some of them are providing the terma.
Yes. And
so I think, but you're not showing the full screen. And I was astounded by how much non-right turbine clutter, bespoking the amazing amount of clutter around the radar head. I mean, the degradation, just even as a non-expert, because you're going to come into me and say, I'm not an air traffic controller, I'm not a radar engineer, but just eyeballing it and having been in the Prestwick control tower for many years and having seen that radar, I was astounded by the degradation in the S511. And that is probably to do with the fact, as Phil Smith said, it's on its way out, it's 31 years old.
yes, but you don't know what steps the airport has taken to remove that clutter from the new screen, which will be available using Terma, do you?
No, because you haven't shown us the full screen. However, you have shown us the screen down to the south, and we can see that Hare Hill, Windy Standard 1 and 2, DeSalec, Hadyard Hill have been removed, and they're the operational wind turbines in that area.
Yes. Right, could I ask Ms. Cornelius to scroll?
And, and Afton, and given Afton and DeSalec funded the purchase of the Termascan 4002 and the Avibit, I would expect they should have been removed. Otherwise, there was no need for those two wind farms to fund the mitigation because Prestwick can provide, doesn't have the lack of clutter. The clutter doesn't have an impact, operational impact on Prestwick's safe and efficient air traffic service.
And the airport having invested with contributions in a radar which has the potential to be wind farm tolerant for new developments as they come along? And if the airport has removed the clutter which appears from existing wind farms which it had to accept, why should the airport...
You did not have to accept this, Alec or Afton. We were both consented with a suspensive condition for, well, not actually a suspensive condition, but where we've done an agreement with Prestwick to fund its mitigation solution.
Well, I acknowledge
Ms.
that.
Mackenzie, could you allow Mr. Brown to ask his questions, please? I'm sorry, thank you.
Thank you, sir. That's very helpful. Thank you. So my question was, Ms. Mackenzie, that if the airport has taken steps to remove clutter from its screens as it moves towards Terma and Terma becoming operational, why should it tolerate clutter from new developments which may create clutter on the ATC's radar screens?
There is no evidence that the Clauchrie's turbines will generate clutter on the Terma displays. And that is, the Terma tracks the turbines as static targets and doesn't report through. At least this is my understanding of how it works. And if Prestwick is saying it's selected a mitigation solution so that it could have the power to turn off or turn on the inherent capabilities of the radar, well, then that's an interesting observation.
Well,
But we haven't established, and I mean, it has not been established. I agree, I'm not the expert to provide that evidence. But I think the idea of saying that you're going to get the kind of images that you get on the S511 from the existing wind farms on the Terma ever, because it is a plot extracted radar, it is a tracking radar, it is quite a different type of radar.
Yes, Ms. Mackenzie, but the fact is that whatever the current screen might look like, and there will no doubt be evidence on this, but whatever the current screen it might look like, the airport has taken steps to remove the clutter, such clutter as appears on the Terma screens from the screen. And
I don't know whether the airport has done it or if that's what Terma does itself. And I think that's the issue for the radar evidence, isn't it?
well, I agree that's the issue for the radar evidence, and I'm certainly not trying to draw you into giving radar evidence here, Ms. Mackenzie, but I'm simply putting to you a proposition that if the airport has taken steps to remove that clutter from the new Terma screens, why should it tolerate any clutter which may arise from new wind farm developments being built within the radar line of sight?
I'm sorry, because there'll be a point of time when the Terma will reach capacity, its mitigation capabilities. So you will want to use that mitigation capacity in airspace that matters, i.e. airspace where any potential turbine impact would have a detrimental on the Terma's detection capabilities, would have a detrimental impact on the safety and efficiency of the air traffic service provided by Prestwick. Effectively, we're back in the same place. Saying the airport's saying it must now have a clean screen because it provides a service of equal import everywhere in its radar line of sight is not true. It is back to the same effective issue. The surveillance infrastructure is there to support the provision of a safe and efficient air traffic service. If airspace is not where Prestwick provides a safe and efficient air traffic service, then if there is some impact on the turbine, and as I said, we're not clear that there is, then there should be no reason why Prestwick suddenly has to have a perfect screen. So I don't think I don't think I'm going to agree with what you're saying. I can see what you're saying. I understand what you're saying, but I don't think saying zero clutter, because I would ask, like, you know, as we can see around Prestwick, the 511, all the traffic clutter and all the other things that have been caught by the radar for all these years. Yeah.
Okay.
Let's come back down to, yeah.
Looking at the bottom, or looking at the screen here, we have the southeast of the radar line of sight at the airport. And this is looking at those turbines which are visible on the radar screens, those which will be visible, the wind farm being currently under construction, those wind farms for which planning permission has been obtained but they're not yet built, those turbines which are in the planning process, and those which are at the scoping stage. And do we see there that in the southwest we've got Hadgert Hill and one at scoping, Macadar, and then next to that Clauchrie, which is obviously the one which we're focusing on in this inquiry. And then we have a range of wind farms at different stages, right up to Kennock's Head Extension 2. You with me in that? See all of that?
Yes, but they are not, all the turbines you're showing are not actually in radar line of sight. The bottom part section of Hadgert now would take you to app 3.43, which is our version of the same map.
But Ms. McKenzie,
And it shows that but you are counting all of Hadgert Hill as being visible. The Hadgert Hill turbines are at less than 140 metres high. Only some of the Hadgert Hill turbines are visible.
yes,
Prestwick is always, so I would just point out that, and I would also point out that not counting Hare Hill, the original turbines, or Windy Standards 1 or 2, which have been visible since, or Windy Standard 1 and Hare Hill have been visible since 2005. But actually, Hare Hill extension is over the hill from Prestwick. It was designed very carefully to keep it out of radar line of sight of Prestwick's primary surveillance radar.
but
So I do question just some of your turbines here, but yes, there are a lot of turbines in this area, if that's what you're trying to say. Yes, there are. It's a very windy part of the world.
yes. And if no mitigation was provided, and I know mitigation is provided for some of them, so we don't need to have that conversation, but if no mitigation was provided for any of these turbines, what effect would that have upon the airport's operations?
But mitigation has been provided. Mitigation has been provided. No, sorry, that is, you're asking me to opine on something which you'll no doubt tell me afterwards I'm not kind of qualified to opine on. But I think you're setting up a counterfactual which is not correct. The airport objected to Afton and the airport lived with Hare Hill. It lived with Windy Standard 1. It didn't object to Windy Standard 2 because it didn't know the difference between radar line of sight and visual line of sight at that stage. It didn't object to Hare Hill because it thought it would have controlled airspace out to there, which it just doesn't. But it lives with those wind farms, and it has been living with those wind farms from 2007 to 2016. Windy Standard 2 has now been built, so there will be more clutter on that area. But the airport objected to Afton, DeSalloch and Kyle, both north and south, which has come back in. And that was because it was in critical airspace. And Afton and DeSalloch, and now Kyle South, could only be built with mitigation. So it has happened. So for what you're saying, you're wanting me to say, if all those wind farms were built and Prestwick had to rely on a primary surveillance radar like the S511, could it provide a service? I'd ask the air traffic controllers to answer that question.
All right, so are you saying that you don't know the answer to that? Is that your position?
Am I an expert to provide that answer, Mr. Brown?
No, well, my question was, you're saying you don't know the position.
Oh, I know Prestwick will say it can't. I know Prestwick will say it can't, but that's why it's a foolish question. I'm sorry, I do think it's a foolish, because the counterfactual is wrong. There is mitigation.
Well, I was
has been funded by wind farm developers, and Prestwick eventually one day will commission it into service.
Miss Mackenzie, I wasn't trying to.
Summer.
Miss Mackenzie, it will help if we recognise the conventional process here that I ask the question, you wait till I've finished, I wait until you've finished your answer. I think that'll make it a much smoother process and a much more beneficial one for the inquiry. I wasn't trying to put any counterfactual position to you because I was quite clear in my question. If no mitigation had been provided or would be provided for any of these wind farms, what effect would that have on the airport's operations?
It would make provision of a ATS based on primary surveillance radar difficult.
But not difficult if there was mitigation for the effects of the turbines.
But yes, and that's why Prestwick, DeSallick and Afton funded the TS 4002.
And would you accept that each of these developments shown would make or are making or would make a contribution to the overall issue which would arise from the southeast right up to the northwest, so far as clutter is concerned?
Only to the extent that, as you've said, that there might have to be, if necessary, which we haven't established yet, optimisation per wind farm, a single one-off activity.
And
not a waffle pattern flight trial to determine the actual probability of detection of the radar before it is, which should be established when it did its commissioning flight trials. So yes, if the man from Terma has to come and tweak the radar after the turbines are built just to make it, make it optimal, then it's a single one-off cost, which, as I've acknowledged before, if necessarily required, should fairly, the cost should be recovered, can be recovered. But it is what was actually reasonably expended. It is about repairing the impact, not about betterment.
now, looking at Clauchrie, Miss Mackenzie, and where it sits in the range of wind turbine farms or wind farms which we've been discussing, would you accept that, again, on the hypothesis, if none of these wind farms had been or were to be mitigated, that Clauchrie would also make a contribution to the clutter which would appear on the screens at the airport, the radar screens at the airport?
This is on the basis that the 511 remains Prestwick's only radar.
What about on the basis that, in actual fact, special steps are required to be taken to optimise the Terma screen to make sure that clutter is removed?
No, but if the Terma screen is already the radar being in use, neither DeSallick nor Hajar Hill nor Afton nor Hare Hill nor Windy Standard, nor I assume now it's in construction Kyle South, nor Windy Rig. Prestwick says Windy Rig's in construction. I understand Sandy now's in construction. None of those will show either because they've all paid towards that £8 million that's in Prestwick's piggy bank.
Miss Mackenzie, if no steps were taken by the airport to mitigate or optimise the Terma screen to remove the effect of the clutter, and I'm being quite clear, it's on the hypothesis of if no steps were taken, would Clauchrie not make a contribution to the clutter which would appear?
If the radar is the S511, yes, the radar line of sight turbines of Clauchrie could be detected by the radar and could be painted, could paint as.
No, I think
If it's the 511, that's fine. If it's the Terma, that is not established yet, and that's for the radar evidence.
okay.
It is not what the white paper says, and I know there is a dispute as to whether the white paper is still accurate, but I would have thought Terma would be wanting to improve their product rather than diminish their product since 2012. So I think as a baseline, the white paper is a good starting point, and that's where we do have a disagreement. So yes, they are in radar line of sight. There is a potential 10 turbines definitely, potentially an 11th, are in radar line of sight of Prestwick's radars. If it's the 511, which we all agree is not a wind farm tolerant radar, it's an old radar, it was quite clever in its time, but it's old and doesn't have the ability to deal with this. Yes, it is possible that those turbines would appear. It would paint. And as you find from watching radars, turbines don't paint every rotation. They paint perhaps once every 4 rotations, depending on the yaw angle and the wind. So there's a lot of things that go into it. But yes, there's a possibility there would be some clutter down there.
Yeah,
But it comes down to whether that's relevant airspace and you're providing a service in. Because if you're not providing a service, it's immaterial, as Prestwick has shown with Kelburn and Miller Hill and Wardlaw Wood and Ardrossan for the last 15 years. Yeah, and if it's a Terma, we don't know. That's the problem. I've read the white paper. I understand it says one thing. I understand Prestwick says it says something else. And again, I will defer to the radar gurus on that. I can only read what I have read in the white paper.
If the conclusion is that Terma will have to be optimised to remove the effects of wind farm turbine clutter, and I'll make it clear that I'm proceeding on that basis. And the second part to my question is, and if it is held that optimisation is required, then if no optimisation was provided for this range of wind farm turbines, would you accept that the Clauchrie development would make a contribution to the clutter which would appear on the radar screens for Terma?
I don't know. Because the white paper says, so on the assumption, okay, I'm taking your premise that the Terma is in service, that it is found that any impact on a radar in this area, the turbines are in radar line of sight of the Terma, or some of them are, that there would be an adverse impact on the ATS, which is a big if, but we'll take that as an if. And no optimisation took place. Would there be clutter? It is not clear to me, based on the Terma white paper, that there would be. However, I think what you're asking for is basically, wouldn't we, if there is an impact on our ATS, would you have to pay for optimisation? And if it can be demonstrated that the Terma does not do it automatically, that there would be the impact of that, however, it may not be clutter as such, maybe, well, it may not actually paint as clutter, but if in that area there was a diminishment of the Terma's capabilities from its normal kind of 95% plus PD, then, and this would have a detrimental impact on the air traffic service provided by Prestwick Airport, then it may be fair for that optimisation to be undertaken. But there are lots of ifs in that. So, and it is just that one off, the Terma man in the Terma truck.
Ms. McKenzie, my question was that if optimisation of Terma is required, and if no optimisation was provided for this range of turbines, would you accept that the Clauchrie development would make a contribution to the clutter on the radar screens for Terma?
And as I've said, I don't know. You're saying if it's optimization is required, that may be to take it from kind of 92% perfect to 95% perfect. Prestwick will say it needs to be optimized, but it may not have a detrimental impact on the service. And so I don't know.
All right. Now, do we see to the left-hand side of Clauchrie, or to the west and slightly to the north, we see Hadyard Hill there. You got that?
Yes.
Right. If we could just use that as a reference point for the moment. Now, in your recognition, you say at paragraph 7 that GPA, and this is the last sentence, GPA 4048 demonstrate that no traffic receiving a service from GPA operates in the vicinity of the proposed development. That's what you've said in your recognition. Could I ask Ms. Cornelius to bring up on screen that the video GPA 47, please? 47? 47? GPA 47, sorry. And could you advance that, please, to 2 minutes and 10 seconds, please? Now, we see there in the bottom left-hand side of our screens what is an aircraft with a trail, and it's RYR61. You have that?
Yep.
And we see just to the north of that, that we have an area of green and yellow returns. And would you accept that that's Hadyard Hill?
Yes.
Yep. Could I ask Ms. Cornelius just to play from here? And could I ask that we watch what happens to the flight?
It's 080 or 060. I think it's at 8,000 feet, isn't it?
Yeah, if you stop there.
Yes, it's 7,000 feet, 7,900 feet now and descending.
Yes, but what, if we were to look for Clauchrie here, would it not now be to the south east of the trail for the aircraft which we've been looking at, slightly to the
Well,
southeast?
the Clauchrie airspace is largely off screen.
Well, you sure about that?
No, a few of the turbines, no, well, I'm looking at a few of the turbines to the north, but you can, I mean, none of us can go on point, but you can see where the airway flight level 55 comes in. And so, yes, the northernmost Clauchrie turbines would be probably given it, I took the ADS-B feed from Flight Radar 24 for Ryanair 61 on the inbound, and I have plotted into our GIS map. Again, we haven't provided this, because I was interested to see what separation the Prestwick controllers did from Hadyard Hill to the aircraft, and it was less than 1.5 nautical miles, or around about 1.5 nautical miles. So Clauchrie turbines would be probably 2.5 nautical miles to the south of the yellow blob. Well, that would be the most the easternmost of the northernmost of the turbines, and I think on that particular image only one or maybe two turbines would be visible. I know your drawing shows more, but I must admit if we go into the picture from app in
Well, my point.
in our inquiry statement for aviation, I think we've also plotted it, and yeah, we'll just.
Right.
But anyhow, most of Clauchrie's airspace is in fact
The point you have made in your in your precognition is that GPA does not operate in the vicinity of the proposed development, and I'm putting it to you that in fact it does operate in the vicinity of the proposed development.
No, that aircraft is at 7,900 feet. It is in Nat's. It's in Nat's airspace, and I mean it all comes down to what is the vicinity. We've had this. I mean, Prestwick says the Clauchrie is in the vicinity of Prestwick Airport, even though it's 10 nautical miles outside Prestwick's controlled airspace. I think we're going to differ as to whether there is an aircraft. Actually, in fact, the interesting thing, if we go to the airspace change document,
Well, Ms.
I think it's
McKenzie,
no, but it's very interesting. We can look at the heat map on the airspace change document, and I took an extract of this. And none of the aircraft actually go anywhere near Clauchrie. I mean, it's just interesting. These were actual radar recordings from a summer, 2017, when there was quite busy. And so saying that Prestwick operates in the vicinity of, when this aircraft is being vectored by a controller, knowing the camera's on him, and they're cutting a corner. It's interesting that this is such a used path. It wasn't included as a new instrument flight procedure, but that's, I'm sure, a discussion you and my colleague, Mr. Wiley, will have. But as I said, if we look at the heat map from the airspace change document, yeah. So it's a question of what you say is in the vicinity. And
well,
I can see you say 2.5 nautical miles is in the vicinity when the aircraft is in NATS en routes controlled airspace. I don't think it actually is relevant in the vicinity, and I will defer to my colleague, Mr. Wiley, to explain to you in technical air traffic control terms as to why.
yeah.
Mackenzie, can you just give me the reference number for that document you were just referring to?
Waving about, that's the airspace change proposal. It's CD 9.11. Actually, it appears twice. CD 9.11 and CD 9.18. We double count it. Sorry about that. And it's figure 3. And this is actually a version of this I did for my own purpose, which just shows it's actually a heat map of all arrivals and departures at Prestwick Airport. I'm sure I was looking at the wrong camera. And I just tried to basically, as part of the airspace change proposal, and it shows the grey lines mean 1 flight per day, and the other colours are more flights per day. But the northernmost turbine of Clauchrie is just, Clauchrie is basically off this map, but the northernmost turbine of Clauchrie is basically there and not underneath where any flights per day appear. And again, I'd observe that most of these turbines will be in a NATS en routes airspace.
Yes, but the point is, Mackenzie, that you have said that there is no traffic receiving a service from GPA in the vicinity of the proposed development. You not?
It depends on the definition of your definition of vicinity. I can see that you think 2.5 nautical miles is in the vicinity. So yes, that aircraft has been handed over from NATS en route to Prestwick, and it is being controlled in that airspace. Yes.
And being controlled by Prestwick in that airspace. Being controlled by the airport in that airspace.
NATS en route airspace, yes.
Yes. But just
they don't fly their instrument flight procedures. But
well, Ms. Mackenzie,
okay, fine, yes.
I thought we had an understanding that I would ask the question, you would wait till I'd finished asking the question, I would wait for your answer and ask another question. Now, I think you acknowledged in that answer you gave that the flight had been transferred from Nats to Prestwick. Do you not?
Well, that is what the that's what the video of the audio part of the video indicates.
Yes. Yes. And if we hear from Mr. Smith that he was providing the service at that point, you would have no reason to doubt that, would you?
No, he was clearly. We heard him providing a service.
Yes.
And vectoring the aircraft.
Yes. So, do you now accept that the airport does in fact provide services in the vicinity of the development?
It can.
Yes.
Yes.
And as we can see from this video, it's more than it can, it does. Does it not?
But that aircraft is in transponder mandatory territory, and it is quite.
Now, Miss Mackenzie, that wasn't my question. My question.
Yes, your question is, does Prestwick, and my kind of observation would have been nice to have seen not staged approaches taken for the camera. But yes, in the instance of GPA 48, the inbound Ryanair is receiving a service from Prestwick Airport.
Yes.
And it is within 3 nautical miles, I would think, 3 to 5 nautical miles of Clauchrie in Nats en Route's airspace.
But it contradicts this unequivocal statement you have made at the end of paragraph 7 that there's no traffic service in that area.
My apologies, I have made a mistake. Well, my mistake.
Right,
It was the definition of no. I'll actually rephrase that. It's the definition of in the vicinity of.
Yes,
but that's the definition of the GPA definition of in the vicinity of is very large. I would still maintain if you say within the vicinity of, it's like within 5 nautical miles. Yes, they were providing a service within 5 nautical miles.
Oh, right.
But over the top of it, given that most of that screen does not show the Clauchrie wind farm.
Could I ask Ms. Cornelius to bring up the next video, which is GPA 48, please? Thank you. And I think you acknowledged, Ms. Mackenzie, in paragraph 8 of your recognition that these were made on the 8th of April 2021.
We can't actually see any.
Yes.
We haven't got the full screen. We don't actually see what the actual. It would have been nice if we had been able to see the full screen, so you could see what functionality the controller had selected. But yeah. Well, so we have to take your word for that.
Yes, well, we can hear from Mr. Smith on that point.
Full screen. Unfortunately, we can't see where Kelburn is up the north. None of them,
Yeah, but of course, what we're looking at here, or we know, is the area in which Clauchrie is proposed. Now, could I ask?
I think the air traffic controller will be looking at the whole screen in context to provide a safe service. So all that wonderful clutter down around the airport and kind of coming down on the fathers, which is not turbine clutter and it's not ships and it's not inbound aircraft, they'd be dealing with that as well.
No.
And I think are there cars on the hill coming down from into air? Anyhow.
Now, do we see again, Ms. Mackenzie, the green clutter caused by Hadyard Hill? Maybe Miss Cornelius could move her cursor over it. Yeah. Do you accept that's Hadyard Hill?
Correct.
Yeah. Now, can I ask Miss Cornelius to move the video forward to 2 minutes and 50 seconds, please? And what we're looking for is an aircraft which is marked EILCM 081. Okay. And if that could just be played from that point. And if you could just stop at that point. Thank you. Now, Ms. Mackenzie, would you accept that the proposed development at Clauchrie would be just to the southwest of the route the aircraft is taking?
Equidistance between Hadyard Hill and the aircraft on the other side, yep.
So would that be in the vicinity of Clauchrie?
You say yes, at 7,000 feet, I'm not entirely sure it is because it's in laterally, vertically different airspace, but yes, from your perspective, it is in the vicinity of Clauchrie.
Yes, and you've obviously listened to the recordings. Do you accept that this was again an aircraft which was under the control of Mr. Smith?
Yes, he was providing vectoring instructions.
So you accept, do you, that just as with the video we looked at before, that this video also establishes that your statement at the end of paragraph 7 that the airport does not provide a service in the vicinity of the development. Do you accept that's incorrect?
It would appear,
Sorry, it would appear what? Sorry,
it would appear, I mean, I still have an issue about the vertical separation. So in a way, vertically it doesn't, but yes, laterally it is in the vicinity. If you say in the vicinity is less than, we'll say, 5 nautical miles.
So we have, and I appreciate you have said before that we won't, that you don't know for sure when these were taken in, but you said in your inquiries recognition that they appear to be late of April. We'll hear from Mr. Smith on that. But would you accept that here we have, in the course of one day, 2 flight movements which you accept are in the vicinity of Clauchrie?
Laterally, but not vertically. And that's a key distinction.
And would you accept that these flights were under...
And can I also add one of that? And it was by the choice of the air traffic controller that he cut that corner and routed them that way. So it was in the gift of the air traffic controller vectoring that aircraft rather than having the aircraft fly the instrument flight procedures, which are actually designed for more efficient and safer approaches.
But does that not illustrate the point about why it's so important that the airport has flexibility in the airspace surrounding it, so it can use the airspace freely without...
It is not Prestwick's airspace.
I didn't say it was.
Prestwick's airspace end? Does it end Barrow-in-Furness and in Inverness? The idea that this is all Prestwick's airspace, Mr. Brown, This is NATS en route's airspace. The aircraft is still at 7,000 feet and descending. It has been handed over to Prestwick early by NATS. If Prestwick, the aircraft should have been should have been routed to Turnberry then come in all likelihood. Prestwick Airport chose to take different approaches, which are, according to its airspace change proposal, actually less efficient and less safe, arguably. So I think you're sitting to all this is Prestwick's airspace. Prestwick owns the airspace. Well, that's not a given. And Prestwick has to work within this is NATS's airspace here. And Prestwick's controller decided to do what he chose to do, knowing possibly that the camera was on him.
Oh, so are you suggesting, Miss Mackenzie, that these videos were specially shot for the purpose of this inquiry?
They were.
Yes, but are you suggesting there was an ulterior motive in when they were taken, in that the air traffic controller deliberately chose to vector the aircraft in this direction to establish that there was a service in that area? Is that what you're saying?
I don't know. All I'm saying is that these were not random recordings. If we had have got the July recordings last year and this had been shown, then that would have been perfect.
Are you suggesting, Ms. Mackenzie, that the airport has come to this inquiry trying to make a false representation?
No. I'm just saying if we had have had a randomised selection, as I suggested for the July last year, then any question about it would have been, and I must admit the kind of issue about if this is a vector so used by Prestwick, why it wasn't included in its airspace change. And given that in the airspace change proposal, it's like the heat maps, no aircraft are actually shown flying that way, which is, you know, there's actual evidence of where aircraft fly, and they don't seem to fly far over. They are flying quite clearly on the heat map, you know, a good number of miles away. So I think the evidence is that I don't know what was going through Mr. Smith's mind on the day. He provided the service. It was handed over from NATS. All I'm saying is that vertically, it is not in the vicinity. You would argue, your position is laterally it is, and that is a matter of definition. And
we'll clarify with Mr. Smith when we get to his evidence for what he was doing that day. But I asked you a question earlier about whether this demonstrated that the airport had to retain flexibility in the airspace around the airport. And I certainly wasn't trying to suggest that the airport owned the airspace, but does this not demonstrate why it's important that there is flexibility in the airspace? And does it not demonstrate why it's so important to make sure that there is no clutter on the radar screens, because that allows air traffic controllers at the airport to vector aircraft, such as the two we've just looked at in the area of Clauchrie?
Unfortunately, there were the two instances where you didn't provide both the S511 and the Terma feed of the same approach. But if we had been on the Terma, the aircraft would have probably been put on even more efficient routing, which would have taken it over the top of Hadyard Hill and over the top of DeSalloch. But as we know, those from the videos we've got of the Terma, that clutter has been removed. So that is a kind of the issue of you're saying the airport needs flexibility to play. Basically, you're trying to paint a picture of the airport has to be able to play do a slalom. You're suggesting we're going to be doing a slalom through the wind farms, but once the Terma's commissioned, there is no turbines to be slalom through, and this is not in the airspace. It's on the very edge of their airspace. Well, not the airspace, but where they provide a service. And yes, I will now acknowledge that Mr. Smith was providing a service to both those aircraft laterally in the vicinity of Clauchrie, defining how you the vicinity, but within 5 nautical miles, so yes, we'll say, but not vertically within the vicinity of Clauchrie, as in not in uncontrolled airspace, in that's on routes uncontrolled airspace with a buffer of 1,500 feet beneath it of controlled airspace. So, that's fine, but the issue about the baseline with the terma is there is no clutter for all the legacy wind farms, the ones that funded the mitigation and the ones that just benefited from it, which were legacy. And it's not clear yet that the terma does require optimisation and it would actually paint as clutter. So whether anything would come through and whether that on a tracking radar would have any impact, given the evidence that how we understand the tracker to work from the base of the white paper, and there would not be any opportunity for either dropping tracks. And that was set out in Appendix 14.2, I think, of the EIA report, our aviation, the aviation impact assessment. So, okay, I have conceded that laterally those 2 aircraft were in the vicinity of where Clauchrie would be. If, however, terma was operational, even if Clauchrie was not optimised, the aircraft would be put on a more direct routing, which would in fact take it for the north towards Hadyard Hill, the SALAC, which have been mitigated.
Yes, and does that not illustrate the point, Ms Mackenzie, that the benefit of having wind farms optimised out so that there's no clutter on the radar screen is that it does allow for more efficient routings because the controller no longer has to route round the clutter which appears on the screens?
I would ask then why Prestwick's airspace change proposal did not make any reference to radar clutter and routing around turbines when it was put in 2017, when the DeSalAC clutter was already there and the transition TRN2 Romeo was put in place and has not been removed from service in the AIP. I think what we're being asked here, what you're asking me is, isn't it better that Prestwick has a total blank sheet of paper, has a perfect radar screen all the time? Have any degradation because of the traffic going around the ring road? It doesn't have any degradation due to weather. It doesn't have any degradation due to anything. I expect probably everyone's a perfect world like that. But it is where the bulk of Prestwick's operations are. And I think that's really coming in from inside Prestwick's controlled airspace, coming in from Turnberry. And then that's where the issue of turning over the Kyle North area, Kyle South, Kyle North area is.
Yes, and you said...
Mr. Brown, I don't know if there's a suitable time for a break.
Sorry, I've just got one more question on this chapter. Good. Thank you. I was conscious of the hour. Now, you said that if we looked at the terma screen, the clutter wouldn't be there. And I think you were referring to DeSalAC and Hadyard Hill. But, of course, and we've had this discussion, so I'm putting it to you in the hypothesis that absent optimisation of terma, should permission be granted for Clauchrie, that it would appear on the terma screen. The fact is that...
My paper says it will not.
Yes, but my question was posited on the basis that optimisation would be required.
No. You're saying optimisation.
Please allow Mr. Brown to ask the question, and then you can make your point. Mr. Brown.
Thank you, sir. Ms. Mackenzie, just to go back to where we were with this question. You said that if we were to look at the terma screen, we would not see the clutter, which appears on this screen. And I was saying to you that on the hypothesis that absent optimization, the Clauchrie development would appear as clutter on the Terma screen. So it's on that hypothesis. That clutter from Clauchrie would have been a constraint on the air traffic controller, because they would not have had the same flexibility they have if they have a completely blank screen free of clutter.
I do not agree with that statement.
All right, thank you very much.
I don't think it's legitimate for Prestwick to demand it, given what it has been currently operating with and given the constraints of radar.
So, Ms Mackenzie, just on that point, you're now saying that Prestwick is demanding steps be taken?
Yes, Prestwick said it would not remove its objection unless we agreed to pay a per megawatt per annum fee for eternity to mitigate, without actually having done an operational assessment of this airspace. And although you're going to say there were 2 planes in the vicinity, laterally but not vertically, not in Prestwick's airspace, that makes your case. That is not making the case. And we will evidence that, my colleague Mr. Wiley will evidence that. And you've made the assumption that the Terma has no inherent capability to deal with clutter without optimization, and that again has not yet been established.
Yes, Ms Mackenzie, and I've been very careful in the way I've presented those questions on the basis that that is a point which is live before the inquiry. So I'm not trying to put forward a particular position in relation to Terma. Okay, thank you, sir. That's the end of that chapter.
Thank you. Then we'll break there and we'll come back at 2 o'clock, please, and we'll continue at 2 o'clock. Thank you. Good afternoon, that's 2 o'clock. So I'm ready to proceed if others are. Mr. Brown, are you back with us?
Yes, I am, sir. I'm just activating the video.
Fine. And Ms. Mackenzie, are you ready?
Yes, as ready as I'm ever going to be.
Good. Then over to you then, Mr. Brown.
Thank you, sir. Now, Ms. Mackenzie, I want to take you to paragraph 8 of your recognition. And to the sentence at the end of that paragraph, as noted in APP 3.8, GPA is a relatively quiet airport. And Mr. MacLeod took you to that document earlier today, and there's no need to go to it, but APP 3.8 is an analysis of the CAA airport statistics. And my understanding of you going to that document was to show a decline in the air traffic movements at the airport. That's correct, isn't it?
To show, yes, the basic state of play of the airport currently with a 30-year history.
Yeah. But you accept that there are still flight movements at the airport?
Yes, clearly it states there's what. Yes, there are. And
can we agree between us the fundamental business proposition that a business will seek to try to grow its business wherever it can?
Yes, that's what Infratil said, 15 years ago when I joined.
And it's well known that the airport received support from the Scottish Government in 2013. Does that not demonstrate that the airport's important?
Yes, and the Scottish Government is trying to sell it without the £43 million of debt attached to it. £1 million of debt for flying clubs. Nice little one if you can get it.
And do you accept that the South Ayrshire local plan includes in an economic development policy protection for the airport? I can take you to
it has.
Yes. Well, we'll maybe just
that wasn't, you didn't put that on my list of documents to look at, but Air South Ayrshire has always sought to protect the airport.
Yes, well, the document is CD 3.1, which is the South Ayrshire local plan, and I'm looking at electronic page 21 or page 20 on the hard copy.
Just as I haven't actually got this up because this wasn't on my list of documents that you were wanting to cross-examine me on, so I'll just bear with me.
Yeah, thank you.
I think Ms Mackenzie's just having a bit of difficulty accessing the hub, so I think if we just bear with her for a second. Can I just check again, what was the page number? Sorry, I missed that.
Yes, it's electronic page 21. Hard copy, page 20 of CD 3.1, which is the South Ayrshire local plan.
I think Ms Mackenzie's having a bit of difficulty accessing the hub and doesn't have this one downloaded, as she hadn't anticipated being asked questions about it. Is the easiest way for Mr Brown perhaps just to well, there are two ways we could do it. One, I could pass Ms. Mackenzie my computer so she can have a look at it, or two, Mr. Brown can read out whichever part of the policy it is.
Yes. Yes. The other option which we have, of course, is we could share the screen.
If you're able to do that, that would be ideal.
Yes, I think that would be the most beneficial way to do it. Yep. I can just have a moment. Thank you very much. Ms. Mackenzie, you can do that all right?
Not really, but would have been, that's why it would have been nice to have been told. Next to the screen. My apologies. So which bit, oh, maybe it's getting a bit better.
Yep. Yep. Does that help?
Better?
Yep. Yeah. Now, this is the, if you could ask Ms. Cornelius just to scroll down so you see the top of the page. Up, sorry. Yes, this is the, sorry, I think you've gone to another page. Yes, this is the section dealing with economic development in the local plan. And do we see in the white margin on the left-hand side, it says Glasgow Prestwick Airport is an international gateway for Ayrshire in Scotland and has a major effect upon the Ayrshire economy with potential for future growth. We recognise its significance and future potential and want to encourage future growth at the airport in line with the aims of the Scottish Government and is set out in National Planning Framework NPF2. And of course, the issue there is that this was prepared in 2014 and that was the version in place. And if we look at the blue section to the right-hand side, just above where we can see the page, there's a sentence which says development proposals must not have a negative effect on the environment or infrastructure of the airport. And again, if we see, and of course, is that not why, or one of the reasons for South Ayrshire Council objecting, because of the potential impact on the airport?
But basically the terms of their objection was because you objected, they objected. So, yeah.
Okay, and then we see just in the line at the bottom of the page, it starts to protect the current operation of the airport and any associated industrial or office use and make use of the, and make sure of the airport's future economic stability and growth. Development proposals must be in line with the preferred uses shown in the Glasgow Prestwick Airport Strategy map. So,
you omitted the paragraph referring to getting the views of the CAA when obtaining planning permission. That, as far as I'm aware, South Ayrshire Council did not seek any opinion of the CAA.
yeah.
Just,
But
is that correct?
yeah.
The current operation of the airport and any associated associated industrial or office use.
Yes.
To make sure.
But the fact, Mackenzie, that South Ayrshire has a specific policy in relation to the airport.
Strategy plans. That's actually about the footprint of the campus of the plan line. Because I remember Infratil at one stage proposed closing the second runway because it didn't add and seeking to, and that wasn't welcomed by South Ayrshire Council, notwithstanding it would have kept the main runway open.
But the fact that the local plan has this provision in it, does that not reflect that the local council believes that the airport has a contribution to make to the local economy?
Yeah, the local council has always thought that, but what this is about is actually the campus of the airport largely. It's about not allowing the second runway to be turned into houses because of flooding risk, and other things like such that, and actually keeping that kind of block of land together. Yes, so that has been a consistent position of South Ayrshire Council for years.
But when we looked at the column which appears in white, if Ms Cornelius could just scroll up so we can see that the local plan not recognise as well that the airport has the potential for future growth.
As you said before, everything's got the potential for future growth.
Yes.
Of course, you don't exist, in which case there probably isn't a potential for future growth, but while you're alive, there's a potential for future growth.
Yes. So would it not be reasonable to expect that the airport would try to grow the number of flight movements at the airport?
My difficulty is that that's exactly what Infratil was doing in 2005. That's what has been doing for the last 15, 16, actually in fact since 2000. And so, yes, but unfortunately, the aspiration may be to grow the flights, but the trajectory has not reflected the aspiration. And we have to recognise that when trajectories and aspirations don't match, there is potentially an issue.
Yes,
I was observing if the trajectory, and yes, it is legitimate for Prestwick to say it wants to grow. It is legitimate for any business to say it wants to grow. But it has to have a business case to do so. And it cannot have a carte blanche veto over every other development because its right to grow is more important than anybody else's.
well, we'll come to that point.
Come to the MPF4 and the whole issue about bringing, which has been under consultation, the importance of the climate emergency.
Well,
And
we will come to that point, Ms Mackenzie. But when you put before the inquiry that the airport is a relatively quiet airport, what you're inviting the Scottish ministers to determine is that it will always remain a quiet airport.
the evidence of the last 30 years indicates that it has been getting quieter.
But ultimately, when it
So the
comes
last 30 years has shown that Glasgow and Edinburgh airports have got busier, and we'll discount 2020 because it really is. The evidence of the last 30 years has shown that even Inverness has got busier.
but
Comparatively, I'm saying it is a relatively quiet airport. Relatively to the other Central Belt airports, particularly Glasgow and Edinburgh, it is quiet. It has always been quiet.
but you've accepted that.
Heathrow and Gatwick on this list.
Ms Mackenzie, we seem to be getting back into the situation we were in this morning where I'm asking a question and you're attempting to answer. So I would invite you again to follow the practice of me completing my questions. You answer and I'll wait until you've finished your answer. But you accept,
could I just intervene and say that I think Ms Mackenzie understands that point. I think part of the difficulty is that Ms Mackenzie is giving an answer. At some point, he is pausing to consider what she's going to say next. And I think Mr Brown has tried to intervene, assuming that the question has been answered, whereas Ms Mackenzie has not quite finished. So I take Mr Brown's point about Ms Mackenzie not interrupting his questions, but I think there may have been inadvertent interruption of her answers by Mr Brown.
yes, well, sorry, my apologies if that's what happened. I'll be
I think it is difficult with this video conferencing technology to pick up on all the cues about when each other has finished. But at the same time, I think there is a bit of interrupting going on both sides. So and also, Ms Mackenzie, if you could limit yourself to answering the question that's been put. And if there are other points to make, then doubtless your Mr McLeod will raise them in his re-examination. Thank you.
Thank you, sir. Now, Ms Mackenzie, you accepted there are still flight movements at the airport. And one of the issues is that, of course, the radar is there to provide some degree of assurance as to the safety of the airspace, is it not?
Yes.
And that is a benefit which all those who use the airspace acquire, irrespective of the number of flight movements at the airport.
Define airspace. You're right, but I think inherent in this question is the issue of what is the airspace of the airport. The reason an airport has a surveillance system to provide an air traffic services to increase efficiency effectively as you get busier and therefore safety. But if you've got a really quiet airport, arguably you do not need a radar or surveillance apparatus. So that's kind of, but it is where the airspace starts and finishes, and I think that's where we may have different opinions.
Yes, and you correctly made the point there about the provision of a service in the airport. And would you accept that the airport does provide services, air traffic services, in the airspace above Clauchrie?
It is not required to. It can, but it is not required to. And this is the key point, I think, here of all of this.
Now, SPR is seeking a consent.
I might just say I probably was finishing, sorry. The area where Prestwick, and it's set out in the AIP, Mr. von Hoogstraten raised it with a lighting session. It is Prestwick's controlled airspace is the area where it's principally providing a service. There is nowhere stated that it has to, above in the area in the vicinity of Clauchrie, the actual controlled airspace where the aircraft that Prestwick was, was dealing with there were in Nats en Route's controlled airspace. So it is actually Nats en Route to provide this service in that area. And beneath that, it is uncontrolled airspace, so it is no one's airspace. And a pilot is quite at liberty to fly without taking any air traffic service and could as easily contact Nats en Route as it could contact, he or she could contact Prestwick.
Yes, but you accept that the airport can provide a service in the airspace above Clauchrie?
Yes, it can. If it's permitted to by, in that case, it had to be given that delegation. It had to coordinate that with Nats en Route. The inbound, those two inbound flights you showed, they were in Nats en Route's airspace out with any delegated part of the Nats en Route airspace to Prestwick. So it had to be coordinated between Prestwick and Nats en Route. Prestwick could have said, we'll take the flights early. Or Nats en Route could have said, we're busy, they can just go to Turnberry and then you can deal with them. So the issue is that they can, but do they have to? And it is at their airspace to provide the service.
But the fact remains, it does still provide service in the airspace.
2 flights a year. 2 flights a year mean that we can't have renewable energy generation unless we pay a ransom fee to Prestwick of a per megawatt per annum fee for the duration of our wind farm.
Sorry, Ms. Mackenzie, I missed what you said. 2 flights per what?
Well, 2 flights. Well, given actually, well, it does replicate what's found in the airspace change proposal, because that was an area where there was only kind of 1 to 2 flights a day. So you showed us the 1 to 2 flights a day which were in that vicinity.
So, sorry, I thought you
That
said.
doesn't even show much.
Sorry, Ms. Mackenzie, I maybe misheard you, but I thought you said year. So you're saying it's 1 to 2 flights per day?
That particular day. If we had received the whole month's worth of data from July last year, then we would have had a better selection.
Now, Ms. Mackenzie, as I said, SPR is seeking a consent in perpetuity for its proposal, and that's no doubt because SPR wants the benefit of long-term certainty in its business operations. Is that correct in that area? Is that correct?
In large part, it's because it's to do with the actual designation of the land being suitable for wind farms, effectively. the wind farm is you do not provide a time-limited consent to other power generation capability,
Yes, and we
such
find
as a nuclear power station or a coal-fired power station. They are granted in perpetuity. You are granted your consent for your house in perpetuity. It is actually a statement that this is appropriate land for the provision of renewable energy generation using those particular turbines.
yes, that's accepted, Ms Mackenzie, that SPP makes that provision that it should be determined in perpetuity. That's fine. But nonetheless, SPR gets the benefit of knowing it has that consent in perpetuity, and it can frame its business on that basis. Can it not?
Yes.
Yes, and so just as SPR want a benefit in perpetuity, should the airspace around the airport not also be available in perpetuity without the presence of clutter appearing on radar screens?
Is not airspace in the vicinity of the airport.
But it still, as you acknowledged, airspace.
And it is not airspace in the vicinity of the airport in which the airport is mandated to provide an air traffic service as set out in the AIP. Number two, the assumption that that Prestwick, and this will probably no doubt bring us to the onshore wind policy statement, that Prestwick can continue to buy wind farm intolerant infrastructure and expect someone else to pay for it to be mitigated in perpetuity is, I believe, naive and contrary to our achieving our net zero targets. And three, Prestwick is in a monopoly position for the provision of mitigation services. So there are differences. So in our business models.
But the fact remains that the airport does still provide services in that airspace above Clauchrie, does it not?
Does not need to. And if it could not, it would not. It would say to Nats en route, do not hand over that aircraft until it's routing to Turnberry. That's where the aircraft was routing to. It was.
Okay. Can I take you please to paragraph 12 of your precognition? And you say there that Mr. Fido seems to be suggesting that the S511 as a selectable feed would be used as a fallback in the case of a TS 4002 or TERMA outage. This is incorrect. Do you actually know what role the S511 will have going forward?
We were told by Prestwick Airport repeatedly in the context of the Salak wind farm, and most recently in January 2020, that there was no intention to use the S511 long-term, nor was it being integrated into the Avibit. There seems to have been a change of position by Prestwick on that front. It is, however, as Mr. Smith says, at the end of its life, and there appears to be no plan by Prestwick to replace it, nor is there a need to, because Prestwick says the TS 4002 will provide the requisite cover out to 42 nautical miles.
Yes.
Therefore, however, and they say and Mr. Fido says they work in conjunction, and this is exactly what Mr. Thompson at the airport told me on numerous occasions, that it was just a planning radar. Now, the issue here is that, TERMA goes down, we'll have to use the S511. That means you'll have to shut down your turbines. That means there is no certainty of generation for us to actually deliver energy, and the lights might go off, we being the wider energy generation, the wind industry business. But the other important thing is that actually if Prestwick continues to say that it's for its first 42 nautical miles, it's using the terminal, and beyond that, beyond that is the S511, then they together are a single system. And if any one component of your primary radar surveillance system fails, such that it impacts your ability to provide a service, then you have, and I know Prestwick does have, dispensation to go SSR only while those repairs are undertaken, and both pieces of equipment are subject to the same safety management system and repair obligations. And so that is the point of my paragraph 12. So I don't think it's ever likely, no, it is not a feasible and likely, well, it's even stronger than likely situation that the S511 would ever be used. Its only purpose is for providing planning services beyond 42 nautical miles, and it is unclear to me why the airport just does not use the SSR information for those purposes, but that's a question for the airport.
Yes, but what I was putting to you there was that you had said that Mr. Fido was suggesting it was available as a selectable feed, and you're saying it's incorrect. And I'm saying to you,
no, I'm saying not that as a selectable feed, I'm saying as a fallback to the TS 4002 when it fails. His drawing shows that it has now been incorporated in as a selectable feed. So I'm not saying that's incorrect. That's what Mr. Fido says. The question is it a fallback? And then I go on to explain why I do not believe it is a fallback, and therefore why wind farmers should be required to have a shutdown protocol in addition to paying a per megawatt per annum fee. Or maybe we have to pay more if you don't shut us down. Maybe that's the trick that I haven't seen in a new contract. But I don't know. But the incorrect point is about the fallback being the S511, not about it being a selectable feed. Only Mr. Fido knows that, because that is not what I was told before, but that is what he stated, and I believe he says that's what it's now been configured as. Then that's how it's been configured.
okay. Now, could I take you, please, to the Air Traffic Management and Unmanned Aircraft Bill, which is APP 3-10?
Yep. Yeah.
Okay. Now, in your report at paragraph 24, you refer to this document. And in particular, the part you refer to is the part which appears on page 8. And it's the bottom bulleted paragraph where there's discussion about the cost implications of airspace changes.
Paragraph 24 of my report.
Yes, yes. Yes, paragraph 24, sorry. You have that? Yeah, and it's the paragraph which appears at the top of page 7, which I'm looking at, and it's the comment to make that the government responded, setting out the general long-standing policy that air passengers should fund the cost of their travel, including the cost of changes to airspace structure, rather than this being subsidised by the taxpayer, and the amendment was withdrawn. And if we go to page 8 of APP 3-10, I was going to the paragraph at the bottom of that page, which talks about the cost implications of the airspace changes. And you do refer correctly to what was said there about the response which the government had about who was to fund the cost of those airspace changes. But that policy, is that not informed by the general idea that when a passenger flies out of an airport, they are getting the benefit of the airport infrastructure, including the radar. Well, generally the airport infrastructure. Is that not where that's coming from?
I mean, we could turn, the airport recovers its contribution to air traffic control services through the landing fee. And so if we, I think we do put into evidence the currently published
The landing charges.
landing charges. So it is upon landing or parking of the aircraft that the recovery for the air traffic services is obtained. So it's for aircraft, or then there is also training movements. I think if we look at, they were app 3.6 and app 3.7, app 3.6 being the relevant one. So that's the charge for the air traffic control and landing charges. There is a separate, if we're going through app 3.6, you go through to see that there are terminal use charges, which is applied to people using the terminal. They see recovering. So effectively, the air traffic services, the basic standard air traffic services, the aircraft should be paid for through the landing fees.
Yes, but is this not taking us back to the point that ultimately what's happening here is the consumer who gets the benefit of the infrastructure pays?
Remember, the consumer gets the benefit of the one and only radar that is going to be Prestwick's radar, which will be the TS 4002. Prestwick is already funding the SSR feed. Prestwick had a reasonable radar display processor unit. It decided to buy a new one, funded by wind farmers, and it bought a new radar. That is its surveillance suite that the airport requires in order to provide a surveillance radar approach. It effectively got it for free, but that is its basic equipment it needs to provide a service to its customers. So it's not a matter of us benefiting, us the wind farmers. It is the basic infrastructure that, without which the airport cannot provide a surveillance-based air traffic service. Now, it is within the airport can decide it does not wish to provide a surveillance-based air traffic service because it's too quiet. But as you noted before, the airport's aspiration remains, as it has been for the last 15, 20 years, to grow. So
if we look at APP
the
3.10, when this matter was being debated about the cost of airspace changes, this wasn't touching in any way upon costs which might be associated with the mitigation of the effects of wind farms on radar, was it?
I agree entirely, but this is no, I agree. But it is about the principle, and I've heard it repeated on a number of occasions in the context of CAA and DFT observations in the last 15 years I've been involved in this part of the industry, that basically that aviation consumers pay for aviation infrastructure.
Yes.
And since the aviation infrastructure to provide a landing service is the one and only radar that the airport will have, then the ongoing maintenance of it falls to the aviation consumers. It's been a degree of betterment and good luck for the airport that it has managed to get its entire equipment set upgraded for free by wind farmers. Okay, lucky airport. But that doesn't mean everything has to be paid for in perpetuity, because if that hadn't been done, then Prestwick would have had to invest it itself. And it's managed to upgrade its infrastructure without having to invest itself.
Now, I don't expect you to agree with me on this point, Ms. Mackenzie, but if it transpires that there is a cost associated with providing mitigation for the proposed development on Terma. If, that's an if there's a cost associated with that, that cost is not brought about by the airport's commercial operations, is it?
If it selected a radar that actually allowed it to have that veto power and it deactivated any learning functionality inside the radar, yes, it would be, I think. But I don't think we're in that situation. However, this comes back to if optimization is required and the Terma man has to come out and fiddle with the radar for a couple of days, then that is a legitimate cost to seek to recover from the wind farmer. It is not, however, the ongoing maintenance and replacement ad infinitum of that infrastructure. It's a one-off cost if it is required.
Right. And you accept that's a cost?
Quite a reasonable finite cost, you know.
Okay. Thank you. And moving on to the question of electronic conspicuity, I know that I said earlier that we had covered that in the lighting session, and I don't propose to go into that in any detail, but this morning you referred to the air modernisation strategy, which was APP 3.9.
That's the 2020 up. That's the 2020 update.
Yes.
Yeah.
Yes.
Discussed this quite a lot just a week and a half ago.
Sorry?
We discussed this quite a lot a week and a half ago.
That's why I'm not going back to that, Miss Mackenzie. But in connection with paragraph 3.43, you had referred to the fact that for quieter airports, there was some exploration with the CAA about whether EC could be used for quieter airports. Did you know?
Yes, I'm just observing that the world is moving on. I'm not saying it's going to happen tomorrow.
Yes. So you accept that we're not there yet with the introduction of EC?
I accept that there is an uptake, there is a mandate, there is a rebate scheme, there is increasing uptake, there is increasing appetite in the general aviation community, who are the folk who have to actually buy the EC because all your commercial air transport already has it. So we're not there yet in the sense that it's not 2024 and no mandate has been issued. However, I'm just pointing out the whole pit situation is evolving, and it is evolving as we've had the discussion about the Secretary of State's letter.
Yes.
In this direction, and this comes back to Prestwick's, demand for contributions for the duration of the life of the wind farm, irrespective of situation changing. So I'm just basically saying there is work being done for quieter airports. Now, if Prestwick suddenly gets the traffic levels of Edinburgh, clearly that will not work. But if Prestwick continues along in a similar vein to what it currently is, or even if it returns to what it was 5 or 6 years ago, or even 10 years ago, then it may be an option, particularly if Prestwick has to pay for its own radar infrastructure rather than seeking to have energy consumers pay for its essential radar infrastructure.
But what you're doing is you're looking into the future and you're speculating on the introduction of EC, are you not?
I'm setting out what is stated in the Airspace Modernisation Update Report, saying that that was still on track for, was it page 39, still on track for a mandate in 2024.
But we're not there yet with that.
But Prestwick's doing exactly the same. It's saying, but we need mitigation for the next, if your wind farm's 25 years long, 25, 50, 100 years, however long your wind farm's going to be there, we need mitigation. We look into the future, assuming the future will always stay like today. All I'm pointing out is the future will not stay like today.
Yes,
Net zero tells us that.
yes, and if the future will not stay like today, as you put it, then there is the potential for the airport to grow its business as well in the future, is there not?
Yes, within the boundaries of net zero, and I said I would actually bring you back to some of the discussion I have in the in my inquiry report. Basically, on the 6th carbon budget and that area there, basically the acknowledgement that aviation may grow, but not to the extent previously anticipated. So it may be more that growth is, Prestwick's growth may be at Edinburgh or Glasgow's detriment. It may not be that they all grow equally. I think we have to be very honest about that. Demand management is a key element of helping us make net zero. So not saying people are not allowed to fly, but we can't fly as much, and we have to have, sustainable fuels, and we have to electrify campuses. But electrifying airport campuses is the same as electrifying a shopping mall, because essentially that part of an airport is just like a shopping mall or a factory area. That's depending on what kind of land use it is.
But the issue is that, again, you're looking into the future and taking a view on what the future might look like, are you not?
And Prestwick never looks into the future, except for saying it's going to grow. Right.
Yes, but we don't know.
I am being informed by the policy of the government, both the Scottish government and the Her Majesty's government, as to the net zero ambitions and targets, the green recovery, and actually managing to reduce our carbon emissions. So we are all looking into the future in order to meet the policy objectives and now legislative targets of the government.
But fundamentally, we don't know how that policy will fall to be implemented, do we, as we sit here today?
Fair amount. I think I would refer you to the 6th carbon budget and the work of the Climate Change Committee. So I don't think saying, oh, we don't know anything, I think that is quite not correct.
No, I wasn't suggesting we don't know anything, but would it not still be possible for the airport to grow within the context of the 6th carbon budget?
On some of the various scenarios, yes.
Yeah.
Some of them, no.
Okay.
Is overall a lesser growth trajectory than was anticipated before net zero became an issue. So when the aviation white paper, or actually it was a green paper, was Aviation 2050 green paper was consulted on, what, 3 odd years ago. The situation has changed. As I said, we've passed the net zero legislation in the UK.
Yes, but a reporter is having to decide the application today, is he not?
Turbines that will operate in 3-4 years' time to deliver clean, green, renewable energy for the next 50 years or thereabouts, or however long, but for an extended period, allowing us. And one of the major reasons for doing this is because, and perhaps why other considerations have to be balanced, is because of the net zero issue and the need to address the climate emergency and to actually encourage renewable generation and the electrification of terrestrial heat and transport using renewable low carbon energy.
Yes, but there's no suggestion in any of that the airport will not still be providing services in the future, air traffic services in the future, is there?
No, but it's in an evolving world. Everything changes for all of us. And in fact, the baseline against which the airport may provide services, and this is what I was saying, just if EC is mandated, when it is mandated, because it will be mandated, there may be some transition period, but it may be that the requirement for primary surveillance radar, as is set out in ICAO document 4444, which we have also, it's one of our CDs, and it is not the only form of surveillance that it can provide a air traffic service. And I'm saying we could evolve, because let's face it, in 1950, there probably wasn't, well, there might have been a radar at Prestwick because of Lend-Lease. In 1935, because Prestwick is a very old airport, there was no radar at Prestwick. Prestwick still provided an air traffic control service. It would have been from the old air traffic control tower with the air traffic controllers looking out the window. Query whether at those days there were still, the aeroplanes had radios on them. Things have evolved, and so it all evolves.
Yes, it all evolves. What we don't know is how matters will evolve in the future. We can look back and see how it evolved, but we can't look forward and see how it will evolve, can we?
A philosophical debate for us to have over a glass of wine.
Well, yes, we'll leave that.
So, I see what you're saying, but I don't know if we're going to actually resolve it here.
We're not. All right. Now, on the question of secondary surveillance radar against primary surveillance radar and EC, you will be aware that Mr. Smith, in paragraph 20 of his recognition, says, PS, and I'll just read it. Yeah, I'll give you a moment.
I'll just grab that, Phil, if I may.
You'll be aware. Sorry, just let me know when you have it.
I now have it. So it's paragraph 20.
20. You'll be aware there that in the last sentence, Mr. Smith says PSR is and for the foreseeable future will remain a vital component in ensuring safety. What would you say in response to that?
It currently is a component of the requirement for it's a component of the air traffic control system. And at the moment, yes. How long foreseeable future is it's the same kind of question we've just been having. Is foreseeable future the next 2 weeks, 2 months, 2 years, 2 decades? It's going to be more than 2 weeks. It's probably going to be more than 2 months. Maybe more than 2 years, but it's going to be well less than 2 decades, more, which is, say, half the lifetime of our wind farm.
Yeah.
So it's working that through.
Okay. And at paragraph 33 of his recognition, if you could turn to that, Mr. Smith says, due to the diverse nature of the airport's operation and the nature of the surrounding airspace, it's considered unlikely it will ever be able to operate in an SSR on the environment. What's your view on that?
I totally disagree. If electronic conspicuity is mandated, it can absolutely provide a service in an SSR on the environment.
Okay.
It's our cooperative surveillance.
Yeah, thank you. Now, I want to take you to the onshore wind policy statement, which is CD 4.12.
Yep.
And this is obviously, thank you. And this is obviously from 2017. And you refer in your report to the fact that wind farm, and it's paragraph 64, that wind farms are no longer the new and unexpected feature that they once were and are an established part of Scotland's landscape. Given this, we expect in the longer term a move on the part of the air navigation industry towards self-management of this issue. This could be achieved through the deployment of wind farm tolerant radar or other technical solutions. Is this not an ongoing work in progress, Ms. Mackenzie?
Which part's an ongoing work in progress?
Well,
The transition to aviation stakeholders taking responsibility for ensuring that their surveillance infrastructure is fit for purpose in the modern built environment, which includes wind turbines. Yes, I've said it before.
yeah.
Yes, that is still ongoing. But it is not going to take 50 years. It's not going to take 30 years. It should take I would love it to take 5 years, but that's why we called it the Aviation 2030 Task Force, because it was probably recognising this decade would be the decade for transition. And lucky Prestwick, it's already got a wind farm tolerant radar. So you're ahead of the curve.
Yeah, and if we were to look at paragraph 42 of your report, and at paragraph 42, you do refer to the focus of moving from mitigation to self-management has been due to the focus of the Aviation 2030 Vision Task Force under the chairmanship of Paul Wheelhouse, Minister for Energy. And then you talk about the letter which you wrote of the 17th September 2019. I don't think I actually have that, but you've quoted from it, and I've got no reason to doubt you've not quoted it correctly, but he says there in the first paragraph you've quoted, you'll be aware of the long-standing work ensuring that both our thriving civil aviation industry and thriving renewables industry can coexist. So,
I mean, we at SPR deployed the first, made the agreement for the first strategic wind farm mitigation solution for Whiteley and Blacklaw, well, Whiteley initially and Whiteley and Blacklaw wind farms with Glasgow Airport, Nats en route, and ultimately Edinburgh Airport. One radar mitigates 3 aviation stakeholders. Without that pioneering advancement in 2005, which was implemented by 2008 and operational when the turbines Whiteley became operational, at least probably 700 megawatts of renewable energy generation, maybe as much as a gigawatt of renewable energy generation in the central belt would not have happened. So that is the kind of collaboration. There was subsequent collaboration between SSC and Nats en route in relation to the Clyde wind farm. And there have been other examples. So there have been piecemeal mitigation solutions which have been extendable but were constrained because they all relied on a hill being in the way of the infill radar, terrain shielding. These new radars, such as the Thermoscanner 4002, have an inherent capability not to require hills.
but in that paragraph of Mr. Wheelhouse's letter, which you have cited, is there not recognition in that both the civil aviation sector and the renewables sector are expected to coexist? It's not that one is to take preference over the other, is it?
Coexistence means being responsible for the things you can actually manage. So we manage the generation of electricity, you manage the provision of air traffic services and ground services. And the coexistence currently could not mean that one profits from the other. And I think this is the point about saying it seems to be you're pointing it as a very zero-sum game, that what must be, if renewables wins, Prestwick loses. That doesn't seem right. So coexistence means, yes, if a new additional piece of kit is required, such as the Kincardine radar was required, it was funded by wind. It was new and it was different. And that was, but just the cost of that actual piece of kit, the actual remediation costs. Similarly, Prestwick has now purchased itself a Thermoscanner 4002 and Avibit funded by wind, and it's been done. It's a one-off. So that's the coexistence, so that it's only the mitigation. It's not the, because I mean, if we look at Ms. Kilpatrick's recognition, it's quite clear she thinks that if we make money out of generating electricity for no investment in the wind farm, GPA should make a profit out of us generating electricity as well. We could say the same. We would want to make a profit out of GPA making profits out of burning fossil fuels. But that seems a bit silly. And not just because GPA is not making a profit particularly, but more importantly, because our core business is generating electricity. We should do that efficiently. Your core business is dealing with aeroplanes, and you should do that efficiently. But you shouldn't expect to be subsidised by other industries.
I'd like to take...
Making sure that the Band-Aid gets paid for, but not the full hospital and everything else.
Okay, and can I take you now to the update, what's short referred to as update to the climate change plan, which is CD 520. And it's to paragraph, it's electronic page 84 and hard copy page 84, and it's paragraph 3.1.41, which says the interaction of wind turbines with aviation radar can sometimes present a barrier to development. We will continue to work with aviation, energy and other stakeholders, exploring best practice for collaboration through our Aviation 2030 Vision Task Force, tackling the technical, regulatory and financial barriers, which will ensure that all radars are wind turbine tolerant, oblique neutral and freeing up more capacity for development. Again, do the words used in that update from December last year not reflect that this is an ongoing work in progress when it comes to the coexistence of renewables and the aviation sector?
For the entire industry, but Prestwick already has, once it's commissioned its thermoscatter 4002, a wind farm tolerant radar. So maybe that other aviation stakeholders are not as advanced as Prestwick in doing this and have. So yes, in that respect, it is not fully, it is still a work in progress, but that doesn't mean everybody's at the same level of progress on that route. You know, everyone's on the same stage on that. So, and I think the key point is that it's about, as I said previously, and it's from the onshore wind policy statement, and the letter from Mr. Wheelhouse, it's about the issue of transitioning the responsibility for adopting wind farm tolerant radar to the aviation industry. Now, effectively, it has been transitioned to Prestwick because its new equipment was bought for it, and its only ongoing cost should be the costs it would have had for the 511, the SSR feed and its RDP before. It's the cost of looking after a radar, looking after an RDP and buying an SSR feed from NATS en route.
Yes, but the issue here is there's nothing in these documents we've looked at which deals with a policy statement on who is to fund the cost of mitigation, is there?
There's already, I would take you to in paragraph 42 of my inquiry report, the penultimate quote, where I added emphasis in the penultimate paragraph. It's in italics, but it's also underlined. In particular, the issue of transitioning the responsibility for adopting wind farm tolerant radar to the aviation industry.
Yes, and that is the bit which...
Mitigation, we've had this conversation about mitigation. Mitigation is about making better, but not, it is not the mitigation has happened. It's really been the purchase of the thermoscatter 4002. It is that, it is not about all the ancillary benefits that Prestwick seeks to recover by, again, its current charging structure.
Well,
and I have admitted that if optimisation is required, the cost of that optimisation would be part of that, because Prestwick has already transitioned to a wind farm tolerant radar.
yes, but none of the documents we have looked at deal with the question of the cost of maintaining mitigation for a particular wind farm development, do they?
Oh, no, sorry. It only happens once. Optimisation happens once if it's required. And then it's just business as usual. It's the airport doing what it should always do. It should be looking after its surveillance infrastructure in order to support its air traffic service. There is no additional work to be done to do wind farm mitigation.
But what if there is
Lots
additional
of it.
work to be done?
There isn't.
You know that for sure, do you?
I think Michael Rees in his letters indicates that. Seems to suggest it has to do perpetual testing. Perhaps that, and this will be evidence that will be brought out later on, but that is not correct. Well, not correct. That is not the case. So, and if Prestwick chooses not to maintain its only primary surveillance radar, then it chooses not to have a surveillance service ATS. That is fine. Probably the wind farmers would be thrilled to bits about that, because then we wouldn't have to go through this painful dance every time. Now that Prestwick has a wind farm tolerant radar, and it will be its only radar.
What if
it should look after it?
Yes, but I think you should acknowledge, Ms. Mackenzie, there is a life expectancy for the radar, is there not? I think you might say 15 to 20 years.
Yes. So, oh, well, unless it's like the S511, which is still going at 31 years. Yep.
Yep.
But on the whole, 15 to 20 years is your average capital cycle for a radar.
Yeah. What if in 15 or 20 years there's still a necessity to mitigate the effect of the Clauchrie wind farm when it comes to replacement of the radar? Who bears the cost of that in your analysis?
If you're saying, if in 15 to 20 years' time, aviation can still is not required to ensure that its surveillance infrastructure is fit for purpose in the modern built environment, i.e., the airports and navigation service providers can pretend they are still living in the 1990s and buy non-wind farm tolerant radars and say, oh, you have to help us mitigate, rather than buying a wind farm tolerant radar. And they will not specify that they want to buy a wind farm tolerant radar because they can, is that what you're saying? So that it's in 15 years time, 15 to 20 years time, if your premise is that airports will still be allowed to pretend it's 1990?
No, that's not my premise at all, Ms. Mackenzie. My premise is this: if we look forward 15 to 20 years' time and the terminal has to be replaced, and there is a specific cost which is incurred in connection with mitigating the effect of the Clauchrie wind farm, who bears the cost of that?
There will not be any specific cost. Prestwick will have to replace its only surveillance radar if it wishes to provide an air traffic service. There will be no cost.
But my question was, there's a
specific. You're saying that the wind farm, the onshore wind policy, your base is, again, you're denying that the airport will ever have to buy surveillance infrastructure that is wind farm tolerant.
No, that's not the basis of my question. My question is, what if there's...
to mitigate then?
Yes, what if there's a specific cost to mitigate the effect of...
There shouldn't be any requirement for, if it's a wind farm tolerant radar, there should be no cost requirement for a mitigation cost. Now, let's say in 15 years' time, Prestwick bought itself another thermoscanner 4002, the next edition of it, because it was so impressed by its current one, and that's great. And at that stage, Prestwick can still say the baseline environment against which I am buying my radar is one without wind turbines. Therefore, I don't have to pay for optimising the radar for the current built environment. I mean, Prestwick, as I understand it, when I visited Prestwick in January 2017, I saw returns from the termo where it was actually detecting the Northern Ireland interconnector, the pylons from the Northern Ireland interconnector. Was Prestwick going to go and turn around to Scottish Power Energy Networks and say, can you please pay us to take out the returns of the pylons from the Northern Ireland interconnector? No, because they were part of the built environment. So in say 2035, 2040, when Prestwick replaces its terma, if there are turbines in that picture, that's part of the baseline environment against which that wind farm is optimised, and it is not the wind farmer's responsibility. It is the airport's responsibility to make sure its surveillance infrastructure accommodates the built environment at the time when the radar is installed. It's just like the towers from the electricity pylons.
Yes, but Ms Mackenzie, we looked at the work of the Aviation 2030 group, and we've agreed that that's an ongoing work in progress. Is there not a possibility that the work of that group will produce a protocol where, for example, if there is a specific cost associated with mitigating the effect of a wind farm when it comes to renewing a wind farm tolerant radar, that the wind farm operator would bear that cost?
It's also possible that the aviation stakeholder bears the cost. These are all future possibilities you're proposing, and you're saying, you want me to say yes, what you're saying is possible, then I'd like you to say yes, what I'm saying is possible, and I think ne'er the twain shall meet. I would think, however, from my knowledge of what we're trying to achieve on the Aviation 2030 task force and the whole movement in the Aviation Management Board on which I sit, as the OWIC MOD joint OWIC MOD Air Defence Task Force, it's all about moving towards coexistence so that mitigation, i.e. band-aids, are no longer required, that the system is configured in such a way that any turbine interference, if any, because different radar technologies deal with it differently, is managed. And I think that's the purpose of this. If we're going to have anything out of the Aviation 2030 task force, it's about using this decade as a period in which aviation stakeholders' baseline surveillance infrastructure is upgraded to be wind farm tolerant. And then they've been given this beautiful present of a wind farm tolerant system. And then they're told, well, now that's the present. You have to look after it. You have to run it. You can't keep coming back to us saying you need more money for it. You either want a system that works in the modern built environment or not. And and as I said, Prestwick's lucky because it's ahead of the curve. It's already got its wind farm tolerant radar.
But the government having set up the Aviation 2030 group, should the group not be left to consider what the solutions to these issues which may arise in the future should look like?
I am one of the members of that group, so you're getting basically an early insight into my input into that group. I have been saying the same thing for a number of years now.
But
Mr. Thompson may have a different position, but this is an evolving piece of work both at a Westminster and Scottish level. And
yes,
you're saying I cannot determine it. I think what you're saying is that I cannot determine what it will do, but neither can Prestwick. But in light of what has been stated as being the objective of transitioning responsibility for wind farm tolerant surveillance to aviation stakeholders, and the transitioning is the key word. It's about the baton change, the handover, the giving of the present. But then actually the aviation stakeholders say thank you and run with that present, or that baton, if you wish to say. And that's where the conversation is. If the aviation stakeholders say we need 7 radars on every one of our airports, well, then that's what they need. But ultimately, they have to pay for the 7 radars to maintain them after the event. And so that's kind of where we're working through.
yes, now you said that you're one member of that group. Your views might not reflect the views of other members of that group. Is that correct?
To be fair to say, at the moment, there is a degree of a dichotomy between the aviation stakeholders and the renewable energy view, half of the group. And this has been exacerbated by increasingly egregious rapacious, exorbitant, choose the word, mitigation charging arrangements being suggested by aviation stakeholders, along with the fact that aviation stakeholder chooses the mitigation, then seeks a large amount of money from a developer, but does not the developer give certainty of generation, does not stand behind the technology they select, demands the right to shut down turbines willy-nilly because it may not like using SSR only, or it may not want to keep an SSR only authorisation, even though that's what the CAA would tell it can and should do. I mean, the irony is that the cost of mitigation has doubled, more than doubled. Well, actually well more than doubled from under the days of the RO. So when we were earning £90 per megawatt hour, we could we would charge X, which actually reflected a division of the actual capex, but now we're being charged 2 or 3X. And then that's going to now be a per annum fee, which has no reference to the actual radar costs £3.5 million. Okay, in 15 years' time, I might need another £3.5 million radar. But I have saved myself having to buy the other radar that I don't have to have anymore.
Now, Ms Mackenzie, you said there was a dichotomy of views between the aviation sector and the renewables sector on this issue. Did you not?
Yes, and I think that was quite demonstrated by one of the documents you put in your aviation's good, renewables are bad. We make, as Ms Kilpatrick said, we make money. You demand a slice of our investment in renewable generation assets. We don't actually demand a slice of investment in your aviation assets. Maybe we should. That does seem a bit silly. But yes, I think at the moment, the aviation stakeholders have reviewed wind farm mitigation's a nice little earner, to put a title on it. And it's particularly a nice little earner after COVID. But it was happening beforehand. You see, if you can get wind farmers to pay for your entire air navigation service provision, like to buy your kit, pay for your staff, pay all your maintenance, well, that means your airport is cheaper to run.
Okay, so there's a dichotomy.
Should that be something that is borne by electricity consumers when it is essential for an airport to provide its core business, which is aviation services? If the airport cannot, its airport's business case cannot sustain its investment in its core aviation services and the infrastructure it requires, then should it be in that business?
So there's a dichotomy of views, and is it not clear from the conversation which we've had this afternoon that there's a variety of issues which arise out of the question of the cost of mitigation for wind farm developments?
I don't. Where's the variety? Apart, could you elucidate the variety you see?
Yes. Well, things such as who is going to maintain the cost of mitigation going forward. If it comes to the point where a wind farm tolerant radar is to be replaced, who is going to meet the cost of any particular optimization which is required for a particular development? We've got, from what you said, the potential advent of SSR and EC and so on. We've got the question of who bears the risk of maintaining mitigation going forward. Are these not all issues which arise between the aviation sector and the renewables sector?
On the last of those, who bears the risk? It's not about maintaining mitigation. It's about having a safe air traffic service. Once an ANSP has determined that it has a safe air traffic service and it's got the requisite equipment in place, the buck stops with it. There is no separate risk to us. It is a holistic piece. And I think that's part of the issue, is like the aviation industry has been trying to hive this off in order to make money. Let's put no bones about it, to make money. And I'll be told that's bad, we make money out of energy generation. But I have a choice as to where I buy my energy from. I can buy it from Scottish Power Renewables, I can buy it from EDF, I can buy it from Octopus. Dealing with Prestwick Airport, do I have any choice as to who I can deal with for mitigation services? No. Can I contest can I make a suggestion as to the best mitigation option is? No. All I can do is write a blank check effectively. And then we're beginning these questions about what happens in 15 to 20 years' time. Well, then by that stage, Prestwick will have had, been operating that particular piece of kit safely, one hopes, and providing a safe
Mackenzie, I
air
think you're
traffic
probably-
service to its.
I think you're straying off the question asked again. Sorry. So if you could try and keep to your answers to the question Mr. Brown has put, please.
Well, it is. That's just like the uncertainties. It's like, I mean, maybe the reality is I didn't actually really understand the question because I don't think there was a question in it.
Well, let's go back to the fact we've been discussing the dichotomy of views, and there's a view which is held by the aviation sector on this question, and there's a view which is held by the renewable sector on this question. And you've said there are various people on this committee. You've got your view, Mr. Thompson's got his view of it. I would hope that from the discussion we've had this afternoon, it's apparent that there are a number of issues in all of this. And does that not explain why the Scottish Government has brought together this Aviation 2030 working group?
Yes, with an attempt to actually use this decade to resolve this issue, yes.
Yes, and the government having brought together the Aviation 2030 group, does that group not have to be left to do the job it's been tasked to do by the Scottish Government to explore all of these issues and hopefully come to some consensual resolution of the issues?
I noticed Mr. Thompson in his precognition indicated there'd been large amounts of discussion about a lot of these topics. There hasn't been to date. He intimated there was more work ongoing. And I think the issue is because we did fall into a bit of abeyance last year because of COVID. And also because no one's wanted to take this ask the hard questions that we're asking in this inquiry of aviation stakeholders. Now the questions are being asked. Maybe out of the back of this, we will be able to have more of a constructive conversation. And it's about, as I said, I like the image of the baton change, of using this decade to transition.
Yes, and yes, and is that, sorry, there seems to be a delay in your sound.
No, I'm just saying we're just using the opportunity of this decade. That's why the 2030, which was to give everybody a fair, particularly well, aviation most and particularly, a fair transition period, and for us to work out a way whereby from 2030 onwards, there was no more need for mitigation.
Yes, and I think I picked you up correctly when you said that perhaps the issues which we've been discussing this afternoon should be taken to the Aviation 2030 group for exploration.
And I expect when it is reconvened, these issues will be ventilated.
Yes, and your hope would be that, the government's hope would be that the aviation sector and the renewable sector will be able to find a solution which is acceptable to both.
I mean, one always wishes for that.
And that's the objective of the Aviation 2030 group. Is it not?
Yes, so wind may take a bit of pain in this decade, but we're not being asked to take pain in 30 or 40 years' time. We also have to understand who owns what risks and who is best placed to manage what risks. And I think it's a key conversation that needs to be had. And also, like, if we'll say your wind farm tolerant radar can only deal with 1,000 turbines, what happens when there's the 1,001st turbine is built? And I think we have to have that conversation. But it may be then we buy the new expanded, better version. But there's a point when it can't always be coming back to the wind industry for the top-ups. But that's what I think we'll work through. And I think looking at the renewables deployment required to make 2030, and particularly some of the onshore wind targets we're looking at for 2030 and 2050 in first instance, 2030 in the shorter run, and repowerings that will come back so that old wind farms, which had comparatively small turbines, which were often over the hill from radars, will be replaced by taller turbines, which are more efficient, but are not over the hill from radars. We have to address that. And that's what I would expect the Vision Task Force to deal with.
And would you also expect the task force to deal with the question of the cost, the solutions that be tabled?
If there was any transparency on costs, yes, it may well do so. It may say to buy a super duper new radar costs 5 million. The airport, any airport, or wasn't planning to buy the new radar, was not planning to invest in a new radar for 10 years, it may need to have its capex expedited. Perhaps the wind industry has to fund that or make a contribution to that and we would work that through, but on a reasonable cost sharing basis.
Yes.
Not with an exorbitant risk premium for possibly illusory risks attached. Being honest about where the risks and, again, who best manages those risks sit.
Yes, but...
And recognising we want certainty of generation. We do need to be able to, when the wind is blowing, the turbines need to turn.
Yes, but at a general level, you would expect the question of cost to be considered by the group.
If there's transparency, but it does require transparency.
All right, thank you. Could I take you to another paragraph in your report? And it's paragraph 89.
Mr. Brown, is this a suitable point to break, or
Well, it may well be,
are you
sir.
nearly finished?
Yes. No, I've still got a little to go, sir, so this might be a suitable point.
Let's do that then. Let's stop there and come back at 3:30, please.
Thank you.
That's 3:30. Sorry, that's rather a short break. Maybe people needed a bit longer, but I'm obviously conscious of the time, and I would quite like to get through Ms. Mackenzie's evidence today. And I know I've got a couple of questions, and doubtless Mr. McLeod will have some re-examination as well. So just if parties could bear that in mind, please. Right, back over to you then, Mr. Brown.
Yeah, thank you, sir. Now, Ms. Mackenzie, if I could take you to paragraph 89 of your report.
I'm there.
And here you're referring to the Innifer Downs decision and the fact that Inspector Lavender said the planning process is concerned with regulating the use and development of land in the public interest and not with the protection of the commercial interest of one organisation or individual against the legitimate business activities of another. In the context of this inquiry, is that really the territory we're in? Is there any need to put the business interests of SPR in competition with those of the airport, given that there is the technology to allow both to coexist? Through
the charging structure of the airport indicated to us per developer, per megawatt, per annum, for as long as the wind farm existed. Banded, as I said before, you know, so 0 to 50 megawatts for SPR would be X per megawatt per annum. 51, I'm not too sure these are the exact bands, but 51 to 200 we'll say is Y per megawatt per annum, and above 200 is Z per megawatt per annum. The airport indicated it was prepared to negotiate on the upper level, you know, when we're getting to lots of megawatts. That is actually it, and they're the figures. That's the problem. It is the commercial interest of Prestwick not seeking just to recover the cost of, we'll say, having the Terma engineer out to optimise the radar for a particular wind farm if required, but it's actually that whole thing of please pay for our entire surveillance suite. And as I said, the numbers I ran through before, and I know we're just worked examples, but if, you know, assuming it was $3 grand, $2 grand or $1 grand in that scenario, SPR and all our wind farms are consented. SPR's paying Prestwick £52,000 a year for, you know, say for 30 years, that's 16 odd million pounds for a radar that costs £3.5 million, which has already been funded. So I think that is where Prestwick's and Ms. Kilpatrick makes it quite clear in her evidence that she sees this as being a commercial negotiation entirely, and that we should just do some kind of deal. So that's where I'm saying Prestwick is putting its commercial interests first and forefront. The other part of this is also Prestwick saying we can't have anything hamper our potential inchoate ability to grow, and this is in this area. This appears in the paragraphs where I'm dealing with Prestwick's future growth trajectories. And I'm not saying Prestwick can't grow, but all I know is that all the arguments about what Prestwick's saying it can and can't do are the same, and its strategy is basically the same as we were being putting forward at Infratil. We were doing military flights at Infratil, we were doing weird and wonderful cargo at Infratil, we were doing fixed-based operations at Infratil. There was the maintenance hangar from Ryanair at Infratil. That's all still there. Okay, Ms. Kilpatrick says that Prestwick no longer seeks to particularly chase the passenger market, but it will no doubt take what it still has and try to be creative about how you make money out of the airport. That's been going on for a long time. It's always been that kind of slightly unusual airport, which makes it quite fun to run, I think, but, you know, it's not your Gatwick or your Heathrow or your Edinburgh or your Glasgow.
Ms. Mackenzie, my point or my question was this, that there's no reason why SPR cannot have its wind farm in the location it wants, and there's no reason why the airport should have to experience clutter on its radar screens, because would you accept that the advent of wind farm tolerant radars, which have the capability of mitigating the effect of a development, allow both interests to coexist without one impeding the other.
Yes, but in the sense that it does assume mitigation is required, which goes back to the other conversation we've had. It does assume that some optimisation, manual intervention is required for every wind farm. But then it does, the bottom line is the cost issue. I mean, it is, Prestwick will not even remove an objection until you've signed a commercial agreement with them, and they'll only talk to you about a commercial agreement in any detail after you've signed what is a one-way NDA, so it can tell the world that you're talking to it, but you can't tell the world you're talking to them. So I think we cannot disentangle those two threads at the moment, which is unfortunate.
Yes, but we don't need to elevate.
If it only costs 10 grand, we'll say it costs 10 grand, every wind farm it costs 10 grand. Now, you knew what the capability of the termo was, you needed to get the termo man out, for a couple of days for each wind farm and probably put them together into one, and it cost each wind farm 10 grand to cover off the benefit from it in the next, for the duration of this 2030, this decade to 2030, then that may well be fine. It's just a question of the actual charging mechanisms that Prestwick have indicated that it's trying to do. And Prestwick says it's irrelevant. It doesn't have to be cost reflective. It's allowed to make money out of this.
Now, Ms. Mackenzie, you mentioned there again the example of the term engineer coming out, and that's one which you referred to in paragraph 15 of your recognition. And you've said that, for example, if it were necessary for the term engineer to attend GPA, the reasonable incurred cost of that visit could be recovered. Now, when you make that statement, I assume that what you're referring to is, in effect, if I can put it this way, the invoice which the airport would receive from Terma for the work which Terma spent on the optimisation. Should that be required?
Yes. And if the airport could evidence that they'd spent, we'll say, 2 days of their time at a day rate of X or Y, that could be recovered.
Yeah, so you accept that soft costs as
Suddenly
well.
become like 2 days of Terma engineer and 2 years of GPA man or woman. I mean, there'd have to be reasonableness to it. So I'm not saying that Prestwick shouldn't, if it actually incurs costs, but if it's not actually, if the Terma guy comes out and it's part of his annual maintenance check, or the NATS guy on behalf of Terma, whoever it may be, it's part of their annual maintenance check. So the actual costs are, there's a synergy there. That's the kind of thing I would hope we could work through in the Aviation 2030 task force, to be a fair recompense.
Okay, thank you. Now, Ms. Mackenzie, moving on to this idea of a wind farm mitigation services agreement. Would one of the fundamentals of a wind farm mitigation services agreement not be that once that's entered into, the airport then has to deal with ensuring that there's mitigation of the effect of the turbines on their...
I'm sorry, it was indicated to us that it still involved a shutdown protocol. So if the airport, that means the airport's actually not standing behind its mitigation. And the other question is, what is the risk? The risk is the risk that the normal airport assumes all the time for providing a safe and efficient air traffic service in its current environment. The equipment has been modified as necessary to accommodate that environment. Once it's there, there's no further issues. If any part of the primary radar system goes down, they use the standard fallback procedures for managing a primary radar outage. There is nothing special. There is nothing extra. There is nothing more. And as I said, Mr. Rees from Terma makes it quite clear that if optimisation is required, it is only required once. It is not required every year. You don't have to fly flight trials every year or anything else like that. So that's my concern. So
But the concept of a wind farm mitigation services agreement is not in and of itself exceptional, is it? I appreciate that you'll say that the terms of it could be controversial, but there's nothing exceptional in the idea of a wind farm mitigation services agreement.
no. I don't think the issue about providing the aviation airport providing services, wind farm mitigation services, the airport is, there's nothing controversial about, if necessary, the airport being funded to provide a new or additional kit that it needs for it to manage its air traffic control service safely. So it's not a services agreement. It's about funding the remediation. One-off.
Now, you've mentioned in the course of your evidence the Kincardine radar. Is that a radar? Is that not a radar which was provided by SPR?
Funded it.
Yes. And has SPR not entered into agreements with those who get the benefit of that radar?
Yes, we have.
And
We have not.
Sorry?
No, keep on going.
Yes. And presumably, I don't want you to tell me the terms, but there would be commercial terms agreed on which the SPR was prepared to do them.
Yes.
So,
But basically all SPR, and we've always made this very clear, we have sought to have a contribution. We are in no way, shape or form have ever recovered the full cost of the Kincardine radar. We have sought to obtain a contribution which reflects the contributions we make for the radar from the beneficiary wind farmers. And we have, unlike the airports, rather than increasing our prices with the closure of the renewable obligations, we have recognised that we've probably made a fair recompense and seek much less contribution from wind farmers. And it is just a small percentage of what we actually have to pay.
yes, but these mitigation services agreements, or whatever you want to call them as,
Services agreements, because the airport, both airports and NATS en route assume responsibility. There are no shutdown clauses. There's an acknowledgement SSR only is the answer if there's a failure. There are requirements if there's an extended outage to obtain a temporary transponder mandatory zone. There is certainty of generation. And so I think it is fair to say, and as I said, we have, rather than doubling our prices, we've kind of cut ours by 2/3. So for a contribution, and it just seemed to be, it's a contribution to our outgoing. It is not a way of making money. Now you could say, well, we shouldn't make any return on it. And that is an argument. And that is a conversation which can be brought to bear in the Aviation 2030 Vision Task Force. But in the same way as NATS makes money from selling the Kincardine, from selling the Cumbernauld and Glasgow Airport radar feeds and the Edinburgh radar feeds. There are a lot of moving parts.
Yes, but fundamentally, when a mitigation services agreement is entered into, it's a commercial agreement between the parties to that agreement, is it not?
It is about funding mitigation, and the airport, this is the fundamental problem. Prestwick thinks it is entitled to basically abuse its dominant market position in the provision of monopoly mitigation services. It is not about giving Prestwick a revenue stream. It is about covering demonstrable and reasonable costs. And the demonstrable and reasonable costs of the TS 4002, the purchase, and that of the Avibit have been covered. And beyond that, Prestwick has recovered another same amount again or more. And is seeking to recover, if they could get £2.5 million a year from wind farmers, that would pay for all its air traffic control staff. It would pay for probably half of its all its maintenance, all its outgoings, probably aerodrome lights, who knows what else. So it's not just a commercial agreement, and I think that is where the fundamental problem is, that Prestwick thinks it has a right to recover more than the cost of remediation.
But it's a commercial arrangement, Ms Mackenzie, to the extent that it will be entered into between a renewables energy company, which is obviously a commercial organisation, and it will be entered into with a radar provider, if I can use that term, which is a commercial organisation. So we've got commercial parties entering into this agreement, or these types of agreements, have we not?
I actually think it's probably something that should be regulated by the CAA Economic Regulation Group.
Yes, but there's no provision.
It's a regulated. Yes, I guess you say that if you enter an arrangement with our grid company, it's a commercial arrangement too. Yes, there is a contract, that there are funds, but it is a regulated arrangement.
And to enter into that contract, there inevitably has to be a negotiation about what its terms will be, does there not?
Only if if mitigation is required, and we come back full circle again, and you would like me to continue to argue on the basis that let's just assume mitigation is required. I'm not prepared to exceed that. I have humoured you to the extent, but that is the first and foremost position. There is no need for a commercial, any kind of contract, any kind of services, if there is no degradation to the air traffic service provided. And then you say it's a commercial negotiation. Well, let's say you do have to do, but if you go directly to term, it costs you X, but we have to be the middleman, so it costs you 10X. But if you want to build your wind farm, you have to sign this, or you have to come through the pain of a public inquiry. Well, maybe a few more developers should actually come through the pain of a public inquiry to actually say, let's have some transparency. Let's say, if it costs X, then be honest. And if we want to move on with the Aviation 2030 work, we have to have that degree of transparency as to where technology works and doesn't work, costs, and being reasonable.
Well,
but it's not behind closed doors, behind NDA negotiation, which is what Prestwick wants.
Well, when commercial entities enter into commercial agreements generally, would it not be usual to expect there's a non-disclosure agreement between the parties to protect?
Remember, Prestwick is doing this through its it's using its safeguarding function to extort demand payment. And I don't think if it's a scheme, it should be prepared, and if it wants to do this, it should be prepared to be transparent about it.
But there's nothing unreasonable about surely the airport and SPR wanting to keep their negotiations confidential.
I would actually quite happily, if the airport was prepared to do it, disclose the terms of the DESALIC agreement and all the concomitant documents that we got underneath it.
Yes, but would the parties have to enter into a non-disclosure agreement so that they could have that conversation if that's what they wanted to have?
No, I think actually what would be good for making this, especially since Prestwick is still a government-owned airport, that we had that. And then Prestwick, as it always tried to be when, we were trying to be the leader of the wind farm mitigation thinking. We were trying to be out of the box and be creative. And it wasn't about actually having future operational day-to-day operations funded by energy consumers. It was about actually being able to deliver and release renewable energy generation so that aviation could continue to burn fossil fuels.
But would there not be a desire to have a non-disclosure agreement to allow that conversation to take place?
Not particularly.
And has the applicant had...
The person that wants a non-disclosure agreement is Prestwick, because it doesn't want anyone to know that it's seeking to recover multiple times of what it's already recovered and been paid for equipment. That it is not about mitigation and this kind of risk that they're taking. There is no risk. It does not want, it's about kind of the cold light of day, the sterilising effects of sunshine. That is what a non-disclosure agreement stops.
So has SPR been asked to sign a non-disclosure agreement to have a discussion?
Yes,
with
we were asked to discuss, and as I said, it was a one-way non-disclosure agreement so that Prestwick could tell the world we were talking to them, but we could not tell the world, we could not even approach the CAA. It was drawn so large broadly. Prestwick said that wasn't what they intended, but that wasn't what the words said. So,
and was SPR not invited to propose what it thought the non-disclosure agreement should look like?
there was some drafting to come back from Prestwick. We had a conversation about it, and Prestwick said, oh yes, we understand, we'll send you back some drafting, but nothing ever happened. And I think at that stage we had realised that we were going to be going down this route.
No.
And number one, and number two, while I am curious, because I think there is an abuse of a dominant market position happening here by Prestwick. And so I'm curious, and that may inform a economic regulation group type inquiry. But the other point is that we still maintain by our position that there is no mitigation required. And the problem about arguing in the alternate always is people will go, we'll just take the easy route. They really wanted that. We do not believe mitigation is required. And that is why we have actually made our case so strongly here, and we'll continue to do so.
But was SPR or its advisors not invited to redraft the non-disclosure agreement, which would be acceptable to SPR?
It is irrelevant. But, sorry, it is irrelevant now. It is water under the bridge.
Well,
No. I've made it clear. I do not believe a government-owned airport should be behind a non-disclosure agreement where it is abusing its dominant market position in the provision of mitigation, monopoly mitigation services. So when they, without NDA, we were told that it was per developer, banded, per megawatt, per annum fee, with a shutdown protocol. We might negotiate it on the top level when you're getting over lots and lots of megawatts. And the only way you would stop paying is if the airport ceased to exist.
Well,
regulations changed, not if PSR was no longer a requirement, because Prestwick was taking a risk unquantified. So that's all we needed to know.
but Ms. McKenzie, if SPR wanted to have a discussion with the airport, and if the airport was saying we would like a non-disclosure agreement here, and SPR was given the opportunity to draft the non-disclosure agreement, why didn't SPR send revised wording back to the airport as to the terms of a non-disclosure agreement?
Bear with me while I get the minutes of that meeting up, because I believe that was an action on GPA, not on us. It is irrelevant, and the fact is we don't believe mitigation is necessary.
Oh, so it was that you didn't believe mitigation was necessary?
Made that clear. That is our whole case. You seem to be grasping onto saying, oh, and it was this kind of basically, can we stop having evidence now? I don't like this kind of public interface about this. Can we go and get into a smoke-filled room without windows and actually hammer out a deal whereby we can all look like winners? I mean, if that was what Prestwick wanted, it should have been much more proactive much earlier. But notwithstanding that, we have made it very clear that this is a wind farm that is not causing, even if it does impact the radar, which we do not believe it does, but we'll park that. That's one piece of evidence to be given. Two, it is not an airspace that Prestwick provides a service in, and there is no detrimental impact on Prestwick's service. And I think we're going to just have to agree to disagree on that, because unfortunately that's, I think, where we've got to. So, yeah.
So what happened here, Ms. McKenzie, was that the airport indicated that it was prepared to have a discussion with SPR if a non-disclosure agreement was signed, but SPR's position was that it didn't believe mitigation was required. So although it was invited to propose terms for a draft NDA or non-disclosure agreement, the SPR just elected not to do that. Is that what it comes down to?
No, I think, and I'm just looking for the minutes of the meeting, it was left, the action was left with Prestwick did not respond with a revised version. We had a discussion and Prestwick was most adamant, but it doesn't, I mean, it was like, and it was like, we all made it clear that any conversation was without prejudice to the inquiry, because our position is that there is no mitigation required.
Yeah, Ms. McKenzie, are you sure that's right? Because I'm being told that, in fact, an email was sent to your solicitors inviting them to propose terms for a non-disclosure agreement. And no response was ever received to that invitation.
Then there was a meeting between the principals. You may not have seen the minutes.
No, I think it was after the meeting.
No, I think it was before the meeting of the that email was sent before the meeting of the, as far as I'm aware. Yes, there was the action was left with Prestwick on what information. Prestwick was to provide SPR with a response to SPR setting what type of information it wishes to keep confidential under the NDA, because it was very, very broad ranging. And there were other matters, but there was the actions of that meeting. The action on us was to draft the first draft of the SOAMs, Statement of Agreed Matters, which we did. And the action on Prestwick was determined because it's the NDA that was sent to us in advance of the, and it was just in advance of the preliminary meeting, the PM, would have made it impossible for us to appear at the inquiry. It would have made it impossible for us to raise any issues. Yeah.
But could the NDA not have been drafted so that it would have been possible for you to still?
The action was on GPA to provide a response to SPR setting out what type of information it wishes to keep confidential under the NDA. And this was a meeting between the principals in February of this year, 24th of February. And we did not hear anything further. We were also told that Prestwick's sale was going to be completed within 8 weeks, which seems to have passed. But and in a way, it is now water under the bridge.
Well,
I think what you're probably I think what you might be trying to say is like, we're using this as to heavy you to do us a sweetheart deal. We actually don't think mitigation is required. That's the core of it. And if it is established that the term doesn't work automatically like the white paper says it does, and this is an area where Prestwick's, it does have a detrimental impact on Prestwick's airspace, then getting the term man out to do an optimization for a few days is all that's required. I think that's the point. It's not this big pay us forever, pay us, X, 500,000, £500,000 a year for the next 50 years.
I've made a note of that, Ms. McKenzie, so I don't think it needs repeating, but I do agree with you that I'm not sure how relevant this line of questioning is, but I dare say there is a point to it, but it's not immediately apparent to me.
Yes, there is, sir. If I can just finish off the point, Ms. McKenzie, there will be evidence later that invitations were sent, or an invitation was sent to SPR on the 2nd and 3rd of March to propose terms for a non-disclosure agreement after the meeting on the 24th of February, but no response was received. And
which document and which recognition do I find that in?
Yeah, well, unfortunately,
Which document of recognition do I find it in? I have not seen that being adduced to date. This is new evidence?
well, we'll leave it there.
I think it's important. I mean, I think it's important that I'm not the lawyer in here, but I think that's, so you're adducing new evidence, which is not in anyone's inquiry report, not in anyone's recognition, and has not really been addressed anywhere. Okay?
Well, yeah, Mr. Mackenzie, you're not the lawyer. That's correct. You're here to answer questions. I'm not saying that might not be a reasonable point, but it's probably not one for you to raise. Thank you.
I'll move on, sir. The fact is, we don't have a non-disclosure agreement. Now, and one of the matters informing that, Ms. Mackenzie, if I'm right, is that you didn't think, or SPR didn't think, that mitigation was required. Now,
It's been the crux of our case.
yeah, all right. Now, at paragraph 98 of your inquiry report, you refer to the high-level principles which you understood the airport was operating on. And at paragraph 101, and we've had this discussion earlier, you refer to the fact that the terma was procured with contributions from wind farm developments, including the applicant in respect of its wind farm of Salloch. Now, when we look at your understanding of the high-level principles, would you agree that what in actual fact the airport was proposing was a different form of agreement because it wasn't looking for capital cost?
It's definitely a different form of agreement. It is recovered a capital cost and an ongoing maintenance fee under the original agreements. It also assumed all risk for deploying the mitigation. It seems that Prestwick no longer assumes the risk of deploying the mitigation because it's still, and I didn't include it here, seeks a shutdown protocol, but it is recorded in the minutes. And that was discussed because I was a bit surprised. I thought, if Prestwick was taking this big risk, it would actually provide us with certainty of generation. So Prestwick's saying, notwithstanding you pay us, we can still turn off your turbines. So you may not actually be able to meet your CFD requirements or fulfill your contractual requirements under your PPA with whoever is buying your energy. The importance of actually having certainty of generation so we can have a business case we can invest in is important, and who manages that kind of risk. So, and given the fact that, as I said before, terms under our agreement gave us insight into what the radar mitigations, what has already been done to date, and insights as to whether there was any need for further contribution.
But although, Ms. Mackenzie, you refer to the high-level principles of use as you have explained them, the fact is that there was never any detailed discussion with the airport about how these high-level principles would be applied, was there?
It was made very clear it was on a per developer basis, so aggregated your portfolio, that it was banded, that the bands reduced, one assumes, so, and that there was a requirement for a shutdown protocol. It was made clear that it didn't matter how many megawatts contributed, the number stayed the same for everybody. So if there was 100 megawatts or a gigawatt contributing, everyone paid the same. So Prestwick made 10 times as much.
But the fact remains,
because undeliverable, unforeseen risks. And yeah.
but the fact remains there was never any detailed discussion about the charges, was there?
No, because we didn't sign an NDA.
Yeah, and so you don't know the detail of how these principles had been framed?
If I'd signed the NDA, I couldn't be here because I would have been gagged.
Well, I think we've had that discussion. You don't know what considerations were factored into account when the airport devised the megawatt charging scheme, do you?
Well, I don't know that they'd tell me even if I'd signed an NDA as to what factors they considered. They just talked about, as they do in their evidence, about risk and the potential that their future growth aspirations may in any way, shape or form be impacted by a wind farm.
You don't know the basis on which the airport decided to move to a different style of agreement, do you?
They made it quite clear that they didn't like the, well, I could posit a reason is that they no longer have to, if a per megawatt per annum fee means it will not be non-recurring revenue, so therefore it can be hidden in the accounts. As a one-off CapEx contribution, it has been disclosed in the accounts as non-recurring revenue, which is why we know the airport has recovered over £8 million. If it becomes a per annum fee, then it would be hidden as non-recurring, as recurring revenue. And so there would be no, transparency.
Did you
So
ever?
I think that may have driven it, but that is just my supposition. I am not in the, you're correct, I have not got an insight into the airport's current thinking. It's just a supposition from outside.
And did SPR ever make a counter proposal to the airport as to the form of a wind farm mitigation agreement?
We do not believe mitigation is required, so why would we?
And you've obviously got a concern about the changing nature of what might be required to provide mitigation going forward. Did SPR ever propose to the airport a sunset clause which would have brought any agreement to an end and certain events coming to fruition?
In respect of what?
Well, you obviously have
DeSalic agreement, to go back and reopen the DeSalic agreement and put a sunset clause in there.
No, you weren't negotiating the DeSalic agreement, you were negotiating agreement with Clauchrie, and
getting an agreement because that would have required mitigation to be required. And you're asking, did we say, oh, we'll pay you so much and you not object to all our wind farms and she'll be apples and we won't tell anybody. Is that what you're proposing we should have done?
No, I wasn't proposing that at all. What I was saying to you was that given that, as is apparent from your evidence this afternoon, you're looking into the future to look at what the shape of radar surveillance may be at an airport and whether primary surveillance radars will continue to be required, whether electronic conspicuity may come in, what all of that might mean for the mitigation of a wind farm. And you've expressed concern about the fact that you were being asked to enter into an agreement in perpetuity. Did SPR ever go back to the airport and say, well, in the event that electronic conspicuity comes in and there is no bespoke mitigation for a wind farm, this agreement will come to an end, just by way of example?
Just like the DeSalic agreement, yes. That's what we've got, isn't it? When wind farm tolerant radar is required.
But I'm asking you whether
Or EC is required. That's what any sensible person would put in any agreement.
yes, but that discussion.
Do we only have to mitigate so long as, if mitigation is required, mitigation is only required for so long as mitigation is required. It's kind of, and it is not necessarily the duration of life of the wind farm.
But that conversation didn't ever take place with the airport so far as Clauchrie is concerned, did it?
No, because we do not believe mitigation is required for Clauchrie.
And while there may be provisions in wind farm mitigation agreements which allow for shutdown of the wind farm, that was not discussed between the SPR and the airport, was it?
Prestwick indicated that they still required a shutdown protocol in their high-level terms, which surprised me.
Yes. But SPR
paid so much, it being paid so much for, and why they couldn't go SSR only, and it's because of this misplaced assumption that suddenly we'll jump back and keep on using the clutter-filled S511 if it's still working. But we don't plan to replace the S511 because why would we pay for 2 radars? Yeah. I'm sorry.
And again, I assume that SPR did not ever go back to the airport to say that sort of clause wouldn't be acceptable here because it wasn't proposed into the discussion, was it?
there was no agreement. I mean, we do not believe mitigation is necessary. We believe, we understand, we know Prestwick has bought itself a wind farm tolerant radar. That's why it bought it. We were one of the most significant funders of that radar. We know how much, or have a very good idea how much that whole package that was tendered through the OJU cost, due to disclosures made under the DeSalec agreement to us. And it just, so, and if Prestwick's now saying to us, oh, SPR, if you had offered to buy us a WAM, a wide area multilateration system, and that means we wouldn't have had to pay Prestwick and SS NATS anymore. Well, if that's what basically Prestwick were wanting, they should have come and asked for it. But I think the answer would have been the same as, well, if that's part of your surveillance infrastructure and you think the feed from a wide area multilateration system, which is a distributed SSR feed, is better than the one you're buying from NATS, that's part of your question. How you fund your actual own surveillance infrastructure, that's part of your essential surveillance infrastructure.
Yeah, the purpose of this exercise this afternoon, Ms Mackenzie, is not for me to put anything to you on behalf of the airport. I'm not seeking to do that. I'm just asking questions about what happened. Now, this morning, you referred to various calculations which you had carried out based upon the megawatt charge. And you in fact, I think, said that you had guessed the costs and what they would be. So
and I did some scenarios, and yes, I might be wrong, but I would think that Prestwick would be wanting for, I would expect that for 0 to 50 megawatts, Prestwick's wanting to earn at least £150,000 a year.
yes, well, we had the calculation this morning, Ms Mackenzie, and I don't think we need to go back through it, but the fact is that you guessed the costs, to use your phrase from this morning.
I did some scenarios, yes.
But you guessed the costs.
No, I think I was informed by what I know to be the costs that Prestwick has recovered, what other aviation stakeholders are seeking to recover, the general state of the market.
Yes, but the
so I think it was quite an informed, and given I understand, it's quite clear from the looking at the agreements, I think though the aviation stakeholders do compare notes, then I can perhaps take my learnings from one to the other and make an educated guess. Yeah, but it's an educated guess. It is an informed assumption. But, you know, you're right, I haven't seen the document.
So you don't know the detail of what was proposed?
Well, nothing was proposed, no.
No. So the calculations which you provided this morning are entirely speculative, are they not?
They're not speculatively. They're informed on, they are speculative, suggests that there's no foundation whatsoever. They are, I think, reasonably informed. As if there was a scale of different costs, and I think they're probably reasonably informed in light of what I know from previous Prestwick costings, both for DeSalec and subsequently, and for other civil aviation stakeholders.
Yeah,
so
well,
I think it's informed, but it's not, I do not know the answer, but I wouldn't say it's entirely speculative.
Okay, well, let me put it this way. Given that you don't know the actual costs which were being proposed for a megawatt charge because there was no discussion about them, you don't actually know what the result of a calculation based upon a megawatt charge would have been, do you?
I don't know what Prestwick's current standard pricing is now.
Yeah.
And I don't know, therefore, as a result, and I wasn't counting in that fund, I wasn't counting the money we'd already paid for DeSalec. That's kind of water under the bridge, and the ongoing cost that DeSalec incurs. It was about just the new wind farms. And I was only counting the megawatts in that I understand to be visible, because I understand Prestwick doesn't seek mitigation for megawatts that are not visible.
Yes. Your answers have been peppered through, Ms Mackenzie, I've noted with that word, and those words, my understanding. But the reality must remain, does it not, that you just don't know what the cost would have come out at?
I did not get a document from Prestwick saying 3 grand, 2 grand, 1 grand, or, 2 grand, 1 grand, 500, or whatever the figures were, no, but it was indicated it was X, then A minus little a minus little b, and it was tranched down.
Yeah. Now, in
Given
your,
as a-
in your inquiry report, you've referred to, and I think we've looked at this before, the CAP document, which is 764, which is CD 9.4. And CD 9.4, which is the CAA policy and guidelines on wind turbines. Now, would it be fair to take this quickly? To be fair to say that this agreement sets an expectation that there should be discussion between an airport and a wind farm company about mitigation and how
Only if
mitigation.
mitigation, we keep on, you say, let's go and talk about mitigation. I say, let's talk about the objection first. If the objection is substantiated and mitigation is required, then we can talk about mitigation. Prestwick's immediate reaction is we don't have to substantiate our objection. We just say no, and we just talk about mitigation. So,
but if mitigation is required, you would expect a conversation to follow after that.
Not believe mitigation is required, and then we come back to the closer extent which I have outlined in my report and in my recognition as to the extent and duration. So the amount, extent and duration of any mitigation support.
But that would all be a matter for discussion once it'd been ascertained whether mitigation is required.
It should be actually pretty bog standard. It shouldn't be something that should be for negotiation. Prestwick should know. It shouldn't be that wind farmer A gets charged 10 and wind farmer B gets charged 100, even though their wind farms are the same size, because and wind farmer C gets, and one would expect there was some, particularly from a government-owned airport, but even not any airport, because their position, their regulatory position, there should be some coherent scheme to it, as
Yes.
there is with the Ministry of Defence.
But if mitigation was required, you would expect an agreement at that point to be entered into between an airport and the wind farm developer.
If that's the way it was, if that was the way it was, yeah, it depends on how it was going to be managed. Yes, it could well be the case then.
Right. Thank you very much, sir. Ms. Mackenzie, I've got no further questions.
Thank you, Mr. Brown. I think I'll press on with my questions, and then we'll ask Mr. McLeod how much time he's got required for his re-examination. We may need to hold that over until the next day. As with the discussion we've just been having, clearly the particular charging mechanism that's being envisaged isn't before me in this inquiry. But the fact of there being some form of radar mitigation scheme is before me. And we have a proposed condition which would require there to be potentially a radar mitigation scheme if that condition were imposed. And it sounds like there has been a level of discussion around what the content of that radar mitigation scheme should contain. But you said it was just high level. You said something about high level terms or something. Did you say?
Please, no, there has been no discussion about. We do not believe any condition is required. We put it in there for completeness. We do not believe any condition. Yeah. And in terms of what any scheme is required, no conversations have been had. Our concern is that Prestwick is seeking to, they're saying they're providing seeking to provide amorphous mitigation services which bear no correlation to any work that needs to be done. If it was determined that 1, there is an impact on the terma, 2, that impact has a detrimental impact on the air traffic service that Prestwick provides, then if that could be remediated by, and I would say, and this is basically intimated by Michael Reese's letter, the terma engineer attending the site and doing a bit of tweaking, I'm sure it's more complicated than that, but doing a bit of work, then that would be, that cost is a cost that could be recovered. The idea that we should be then paying for any wind farmer, should be paying for maintaining what is Prestwick's only surveillance system, etc., etc. So it is, there is no clarity, and I think this is important because of all of these wind farms, this is the one that's the most, it is on the very edges of Prestwick's airspace, and in the past, Prestwick would never have actually objected to it. So,
but you've obviously, there seems to be some suspicion on your part that this radar mitigation scheme is going to contain, or that the airport is going to seek, but to contain items that are objectionable to you. But on the face of it, as proposed, there could be a radar mitigation scheme which just describes the type of activities that you've just mentioned there about the terma engineer coming and there being a standard one-off fee. That might be all that was in this radar mitigation scheme. So it's, I suppose my question is that it's not necessarily the condition itself that you have a problem with, it's your suspicions about what might be in this radar mitigation scheme.
yeah, if, again, assuming that mitigation is required, yes.
Yes, yes. Now, this isn't the conditions session, but I don't know if you're going to be at the conditions session. But if that condition were to be phrased in such a way as to provide more detail, perhaps some limitations on exactly what could be in that radar mitigation scheme. So, for instance, it could say it should not any radar mitigation scheme should not contain an ongoing annual payment. It should be limited to a payment of no more than X. It should only cover the following activities, A, B, and C. Then could that be a way forward, or could there be room for negotiation with the airport about that?
You kind of catch me a little bit on the hop. I can see where you're coming from. I think you might find it would get, it'd be a somewhat, we'd have round 2 in the court, so in an inquiry over the terms of the condition later on. But I think if mitigation is required, which I really, the airspace usage point, just because you've got clutter doesn't mean it needs mitigation, as Prestwick is currently living with. But if there was it was found that, you know, the terma engineer had to, it was best if the terma engineer came, and that was costed it. My concern is that the airport would say, no, we still need everything else. I mean, that's my concern. I just think and that's why I need to think about it a bit more. I think it's not, I don't know if we're just kicking the can down the road. That's my concern. And that's why I wouldn't mind actually thinking about it a bit more without, and we probably can come back to it the conditions session, but I know I can understand what you're saying and what you're asking, but yeah, I'm just a bit hesitant, and as well as the issue about is mitigation required, but we'll park that and what is required. Yeah.
Yes, I mean, if this were a normal planning case, typically there would be a notice of intention from the decision maker to say, I'm minded to grant consent subject to the signing of a legal agreement, which will cover these things. And then the parties will go away, come up with legal agreements, which would be public, and that they'd come back to the decision maker, and then they would make a final decision. So I don't know if you've got any comments on that, or if that's more something for. To be honest, I don't know if that's appropriate for Section 36 case. But
I think I have seen this. Well, again, I'm not the lawyer, and my lawyer might want to kick me, but I think I have seen, but his legs aren't that long.
Well, your lawyer shouldn't be giving you any hints.
No, he's not giving me any hints. So he's not allowed to give me any hints. So sorry, I shouldn't have made light of that way. But I have seen in the past a notice of intention to grant consent for Section 36s, both in Scotland and in England, when they used to do Section 36s in England, on aviation matters and other things. Again, it's all premised on if mitigation is required, and we say it's not. There is that could conceivably be a way of doing it. I think it's really important that there's transparency on it, because the smoke-filled room piece, and it's like, and having, the evidence is established that A, B, and C are required, and so that doesn't mean the kitchen sink is thrown in as well. So that is potentially, but I would like to have that transparency, that it's not like basically puts a gun to our head, so we have to sign up to whatever Prestwich says is required, because otherwise, as I said, I have quite significant concerns about the basis on which Prestwich is seeking to recover. So that may be an option, but I'm not the legal eagle on this one. That's just my thoughts.
Okay, thank you. And I think my only other question was, there are some points in your evidence where you are envisaging a future where airports may not need primary radar at all because of the EC systems and so on. And then we've established that that's not the situation today. Today, radar is required, but there's, in your view, quite a high likelihood that it may not be necessary in the not too distant future. Is the reason why this is being brought up in this session really about you saying, really about the time limited nature of any contribution that you make, saying that you're nodding, yeah. So it's about saying it's conceivable there may be a need in the short term, but in the long term you wouldn't want to be tied into something that would run on into this EC.
I mean, let's say CAP 670 is changed to say that it's the responsibility of aviation stakeholders to ensure their surveillance equipment is wind farm tolerant, their system, however they configure it. That change, that means it wouldn't be, that would be part of their baseline. So that could happen in the future. If the surveillance requirements for providing an air traffic service no longer mandated the use of primary radar, and that would also be a situation where primary radar mitigation, if you don't need primary radar, there's no need for a primary radar mitigation scheme. If the responsibility for making the primary radar fit for purpose is with the airport, there's no need for mitigation because it's their responsibility. So there are kind of two situations where I can envisage mitigation no longer being required. And so if we are retaining primary radar, where we would like to go to is that ultimately the airports and air navigation service providers assume that responsibility. And that's because I think, well, I know it will make the radar manufacturers more responsive as well. But I do think in the fullness of time, as EC does come in, at least in some airspace, quite a lot of airspace, there won't be a need for primary radar. And then the other point we always have to keep totally and utterly separate is the air defence piece, but this is not an air defence issue. And if there was a kind of called homeland security point piece, that's something that the Home Office, MOD, etc., would be in charge of. And that's kind of, it's a different entire, and I think ultimately if that's the way you go, you'll want a 3D primary surveillance structure. And I think that is where we're going towards. And in fact, if you've got a 3D primary surveillance system, wind turbines cease to be this issue that they are, because the problem at the moment is our primary radars in air traffic control are almost entirely 2D. They can't tell how hard the turbine is. You know, it's a turbine or there or there or there. They're just a big volume. So that's kind of where we are.
Good, thank you. That's all I had. Mr. McLeod, I don't know how much time you need with your witness, whether you want to roll over till tomorrow. How do you think?
You'll be pleased to hear, sir. I can be very brief. I actually only have one question for Ms. Mackenzie arising from the questions today. And it relates to some of the questioning from Mr. Brown early this afternoon, Ms. Mackenzie. You'll remember that he was asking you about what might happen in the future if the terma was replaced and there was a specific cost associated with Clauchrie in the future. So in other words, as I understood it, the new terma or the current terma is commissioned, it operates, and at some point in the future, that radar needs to be replaced. And the question was, would it be reasonable for SPR to pay any specific costs associated with Clauchrie at that point in time? And I really just wanted to ask your views and to take an analogy. So let's come back down to earth, as it were, and let's assume that for the Clauchrie wind farm to be constructed, there is a need to build a new roundabout somewhere on the public road network. Okay. Do you accept that SPR should be responsible for the cost of building that roundabout if it was the only reason it was necessary to be put in place was to allow the Clauchrie wind farm to be constructed?
I think the logic is, I understand, yes, we would be required in those circumstances.
And following construction of that roundabout, who would be responsible for maintenance of the roundabout as part of the road?
My understanding would be the relevant roads authority.
Roads authority. And let's suppose that in 15 to 20 years, it was necessary to resurface the entire road network, including the roundabout that SPR had paid for. Would you expect SPR to have to make a contribution towards that resurfacing at that point in time?
No, I would not.
Thank you. And I think so. That's the only point that I wanted to take from Ms. Mackenzie in re-examination.
Thank you very much. Then we'll stop there. So just on the matters that we discussed first thing this morning, I'm expecting potentially some questions to be prepared by the parties, and I'll see them perhaps by the end of tomorrow. Is that the hope?
It's possible, sir. I've not had a chance to check where my side's at in terms of a draft. Obviously, that draft will have to go to Mr. Brown and his team to have a look at and see what comments they have. But we're obviously mindful. We want to get them to you as quickly as we can. So we'll maybe if we could just park that, and we'll give you an update tomorrow morning on where we're at. Okay,
that's fine. And similarly, we'll come to a final decision on the ordering of witnesses tomorrow morning as well, if that would suit. So we'll stop there then. Thank you for your contributions today. And I'm just thinking about timing. We're still early in the week, so we'll stick with 10 o'clock for a start tomorrow morning, please. And I'll see you then.
Thank you, sir.
Thank you.